All right. Good morning again. We're all fired up with equipment and ready to go. We have 3 calendars this morning, although currently Mr. Lonzie Johnson wasn't brought over. So we'll see what's happening on that. What's the update?
They apologize.
As they should. They put him on a helicopter.
I was gonna ask who wants him right now? Do you want him on Zoom or do you want him Thursday?
Could we get, is it possible to get Lindsay here today?
I think so. I'm not sure exactly when.
Okay.
It might be that we, if you want to let family know that we say, let's effectively add them to the final plea calendar, because that would give folks till 1 to get them here.
Okay, that would work, because I do have a pad representative. Right.
Okay. Yeah, if we can let Pat know to be here at 1,
Okay.
that would be great.
Okay. I'll do that.
Thank you, Ms. Nelson.
Welcome.
All right, so we have 2 calendars this morning, a plea and arraignment and an inquiry calendar. We'll start with the plea and arraignment. Positions 1 and 2 are Mr. Robinson, Sheree Robinson, in custody. Thank you. Is it the lower? So this would be Ms. Rios, your cases?
Yes, Your Honor, and I did file an entry for a waiver for both. I just do need to talk to him.
Okay.
But I think, I don't believe he's being held in on these cases. It's another case holding him a PI case.
Okay. Well, he's here, so you can chat with him. I want to say hello. After you've had a chance to talk to him, it could just be bringing him to the door, but just to let him know what's going on. But you've done a waiver already, so we'll just get a scheduling order in?
Yes, Your Honor.
Okay. And any reason we shouldn't move both cases together?
No, in fact, I would like the PI case to hope we can try to get that indicted too.
That's a Ms. Smith production, so you have to talk with her about that, but that'd be great. All right, Kerwin McCallman. Was here twice to.
Judge, he should be on Zoom.
Okay,
Super soon.
I am here.
there you are, Mr. McCallman. This is the 3rd time we're getting together for you to hire an attorney. Tell me where we are in that process.
Yes, sir. As before, I was able to attain some of the funds, but unfortunately, things didn't work out as I had planned, and I wasn't able to get all the resources I needed in order to attain legal representation. I am still working on it, but unfortunately, I wasn't able to do it as I had promised to get it at this point in time. Things didn't fall to the way I expected it to.
Okay. Do you know Ms. Rios? Is this someone you spoke with and he did not qualify, or he's someone who expressed an interest of trying to retain an attorney even though he qualified?
I don't believe he ever qualified. I don't think the public defender was ever on his case.
Okay. I'm looking it up. We'll see. Mr. McCallman, we've sort of reached the point where you either need to be representing yourself until you hire an attorney, if you are ever able to do that, or I need to get appointed counsel to represent you. The allegations are old. They're from October of 23. We're coming up on 2.5 years past that. And I've given you now 3 months to line up an attorney, and that didn't happen. So let me see. Yes.
I have been diligently trying to do so. It's not without any effort at all. I have been trying to do so. Things is just not falling into place for me.
Okay, I hear you. I'm not suggesting you haven't been working hard at it, and I appreciate that you were doing that. I know you had Mr. Smith. Scott Smith was your attorney before this case was indicted. Maybe he helped with bond or something like that. But he was allowed to withdraw. Is that who you're talking with to get back on the case, or are you working with someone else?
I reached out to Mr. Smith, and I had reached out to someone else as well, just to see, who who would try to work with me and work with my situation as well. So there's been two individuals.
Okay. And let me check one thing. All right, so you are not based here. You're based in Ohio, which makes it
Yes, sir.
complicated to try to line this up. Are you employed right now?
Yes, sir. I'm at work as we speak. I just took a quick break to to be here.
Tell me what you do.
I'm a security account manager.
What does that mean you do?
I just manage the security staff of about 30 people or so.
Meaning like a a company that provides security guards, but you're on the management
Yes.
side of that rather than walking around with a flashlight.
Yes, sir.
Okay. How long have you worked there?
Since 2024, May of 2024.
Okay. Who do you support besides yourself?
My wife and daughter.
Okay. Does your wife work?
Yes, sir.
What does she do?
I believe she's in one of the financial officers for her company, or she
Okay.
oversees the payroll.
Okay. Well, I'm at a loss, Mr. McCollum. You've got a dual
the issue
income
I'm having-
household, and you've had 3 months to do this. Why is another month going to make any difference?
So see, the issue I'm having when this situation initially came up, I unaware of me, and I was sort of apprehended here in Ohio, and I had to make bail here. I of my own accord traveled to Atlanta because I wasn't sure what these charges were about, and so I turned myself in Atlanta, Georgia. I was picked up there and I had to make bail there again. So I had like two different loans I had to take out in order to make bail, and that's kind of what's tying me up now because those two instances.
Okay.
But I just recently try to see if I can get an equity loan, maybe to see if that will help. But I've been, doing whatever I can on my end, of course.
Okay. So I just looked at your bond. It's a big number, but it was through a bonding company, I assume.
Yes, sir. I had to make a down payment, of course, in order for them to even move forward with it here in Columbus. And then I had the one in Atlanta as well.
Oh, yeah, you got a big bond. Your bond in Ohio was huge.
Yes, sir.
Has that not, I mean, you shouldn't have to be, that bond should be done now.
I'm still paying on that as well.
Okay. All right. So what do you suggest?
My suggestion, like I said, I just recently, well, I'm in the process, I should say. I don't want to be any untruth. Filling in my application for a equity loan, and I'm hoping that goes through. And if that's the case, then I should be good to go.
And what's the timeline for something like that?
I'm not quite sure. I haven't spoken to the realtor, and I think it takes about, I don't know, maybe 2 or 3 weeks.
I want to set a deadline for you either to be here in person, which I know is inconvenient, which is the point, or to have an attorney have filed an entry of appearance in the case. So we know Mr. McCallman has a lawyer, but I don't want that deadline to be too soon so that you just come all the way down here and say, I haven't even finished applying for the home equity loan. But tell me what you think is a reasonable deadline so that we can say either you are here in person and I'm going to introduce you to the public defender, or a lawyer has filed an entry of appearance and then you can just appear via Zoom like you are doing right now.
Correct. Perhaps sometime in May.
Okay, we have a calendar on May 5. May 5. I'm gonna have you added to that calendar on May 5. You'll get notice. It's gonna go to your address. You seem to have a stable address. Sounds like it because you're gonna take out a home equity loan. You need to be here in person on May 5 unless you have retained a lawyer and that lawyer has filed an entry of appearance. And the lawyer will know what that means. It's just getting something in the docket saying, hey, I'm Mr. McCallman's lawyer. This is who the prosecutor can talk to, and we can finally move this case forward.
Yes, sir.
You feel like you understand what's happening?
Yes, sir. Very much so.
Okay, so May 5, we'll see you again. Oh, that's funny. Ms. Nelson picked the same day. I didn't even see that, but she wanted you to be here on May 5, and that's really what would have driven it. Luckily for me, I picked the right date. So May 5, or a lawyer has filed an entry, and then you'll still have court that date, but you can appear just as you are now, and your lawyer can be here in person, waiving arraignment or doing whatever the lawyer decides is in your best interest, okay?
Yes, sir. Thank you very much.
Any questions?
No, sir.
All right, good luck with everything.
Thank you. Thank you. Bye-bye.
Bye-bye. Rashad Fagan. Ms. Rios, Mr. Fagan has, oh, that's right. This is, I think Ms. Cabrera has it. Is Ms. Cabrera planning on being here, Ms. Nelson?
Yes, she's gonna join via Zoom. I'll reach out to her.
Okay. Mr. Fagan has a lot of moving pieces. You're lucky he's a conflict. Okay. Ivan Dodds. I think he's not here yet. Okay, but he is scheduled to be here? Okay. He's on his way. Great. Okay. We'll handle that. Is Ms. Gordon handling that? Ms. Gordon? Okay, just today, or Ms. Gordon isn't doing, she pulled back from one thing. I can't remember if it was competency docket or juveniles. Okay, so got it. So it will be her case. You'll handle it when Mr. Dodds gets here. Great, thank you. Antavius Hill. Hello, Mr. Hill. Good morning. Mr. Hill, do you have a lawyer? Do you need to talk with the public defender? It is possible. Well, I'm going to have one of the public defenders talk with you, make sure you qualify, and then they'll take it from there, okay? All right, so Ms. Wood, that would be you? Yes. All right, so Ms. Wood will talk with you once we finish calling this calendar. Lexi Armour. Hello, Ms. Armour.
Judge, I think she will be mine based on the entry. I do need to connect with her and get a good number.
Okay. So Ms. Armour, just like with Mr. Hill, I'm gonna have you sit tight. Ms. Wood will talk with you, make sure everything fits, and then she's gonna make an announcement on your behalf after you two have spoken. Jaden Ashley. Hello, Mr. Ashley. I'm all right. How about you? All right. Do you have a lawyer or do you need to talk with a public defender? All right, Ms. Wood, you've got a busy dance card. Artie Leidecker.
I see that, yeah.
Uh-oh, did I?
Figure out which one. I guess the 10th. Position 8 and 9 currently is.
Oh, look at that. So Ms. Armour and Mr. Ashley, I didn't realize, I missed it. You all are co-defendants? And so Ms. Wood can only represent one of you. My guess is, don't quote me on this, but my guess is it's going to be Ms. Armour because I think the public defender was plugged in earlier with Ms. Armour. That does not mean, Mr. Ashley, you got to go find your own lawyer. We will still appoint someone. I'm going to have Ms. Wood talk with you very briefly just to understand your financial situation. She's not going to talk to you about the facts of the case or if you know Ms. Armour or anything like that. But if you qualify financially, she'll let me know, and then we'll get a lawyer appointed to represent you. And it may well be someone who's going to hop on Zoom later this morning, but she won't know for sure. It has to get cleared by the people who end up ultimately paying for it. So today we probably won't be able to figure out if you're waiving arraignment or not. We need to bring you back one more time to get things rolling once that appointment's made. Okay? All right. Thanks, Ms. Simpson. So second chance, Artie Leidecker. All right. Bench warrant, Ms. Smith?
Yes, Your Honor.
And there's Rashad Fagan again. You want, pardon? Resolved. Oh, okay. Okay. Then we have some revocations. Raheem Conley. Ms. Wood, will you be handling that?
I'm not sure, Judge, this is the gentleman who, the last time he was on the calendar, said that he wanted the private attorney.
Yeah, he said he was getting a private attorney because he has 2 unindicted cases and he wanted to have them resolved.
Okay, so we'll need to ask Mr. Conley.
Yes.
All right. We don't know if it's Mr. Olaloye, just he was saying I'm hiring someone.
Solar, or it wasn't Mr.
Yeah.
Okay, well, we'll bring him out in a little bit and ask him. Frederick Avery? Ms. Rios, are you handling that?
Yes, I will, and I'm ready for the creation application.
Okay. Mr. Irvin, I didn't mean to speak over you. Are you handling that case? Oh, he's got 2. Mr. Irvin, you have a bad connection. We can't hear you.
Can you hear me now?
Yes, sir.
Good morning, Your Honor. I'm here for Mr. Dilbert. The state and I have been discussing a matter in terms of negotiations. We've gone back and forth. We're still in the process of it. I think the state wishes to go on the record with respect to what they've offered, and I'll wait for the state to do so. But Mr. Peoples is here. He's present. Bradley Dilbert, I'm sorry, is present on the Zoom call.
Okay, I saw him on a Zoom call. I don't see him on any calendar, so I'm gonna look his case up in a minute, but it's not on one of the calendars this morning. Okay, he's on, we may be able to tackle it. He is on, I see, he's position 7 on this afternoon's calendar.
He
And
did say it was 1 o'clock.
yeah, 1 o'clock, but you're here and Ms. Smith is here and Mr. Peoples is here. So we'll knock that out this morning. Since everyone is together, you're just gonna have to wait a sec because I'm still calling the morning calendar.
That's fine, Judge. Thank you.
Sure. So Ms. Rios, Mr. Avery has 2 cases. You will be managing both those? All right. And is that a revocation we can do today, or you need to talk with Ms. Smith?
I believe we can handle that.
Okay, well, let me know. We also have inquiry calendar. Position 1 is Sental Burse. And he should be in, Deputy Gordon got pulled away. Hold that thought. Burse. He's here, okay. I guess that's Ms. Cabrera. He got picked up on a bench warrant. Gavarius Hill?
My God, she's in custody.
Okay. Okay, so he's en route. All right. Alexis Scott. I think I saw Miss Scott. Hey, Miss Scott, your lawyer, Mr. Hines, have you been in touch with him? Great, we'll wait till he gets here, okay? And then Rashad Fagan again. All right, that's it for this morning's calendar. Is there anyone here who thought they had a case, didn't hear their name called? All right, Ms. Smith, if we go to Bradley Peoples and Mr. Irvin and you, are you able to talk about that case right now?
I'm
All right. Mr. Abadi, good morning. Are you here as a supervisor or did you think you had a case?
Yes, both.
Okay.
I'm here on Mr. Fagan's case.
Oh, okay. All right. Ms. Cabrera is handling those. So when she plugs in, we can knock that out.
Thank you.
What is happening with Ms. Jones Connor's cases? No one showed up initially in front of Emerson for her case, nor did anyone ever say, I had heard she was leaving, but no one said, hey, don't call this case out or it's going to be Fred Smith handling it. What's the management plan for her? Okay.
Which case? Oh, the Dunaway's case.
Yes, exactly. And Emerson and Judge Emerson said, I'll continue it. But at first he said there's no one here from the state for that case. Eventually, I don't know if Ms. Charles talked about it or someone showed up, but yeah, it was C. Jones. We had two Joneses, but C. Jones. And he continued it. I just want to make sure she don't have any other cases on this calendar. So the next one is not till April. I guess people will have backfilled by then.
Yes.
Okay, then we're good.
She had actually was supposed to leave on Tuesday last week, but then Dunaway called her into the trial. She decided she was gonna sit through.
Okay.
So that was the reason.
That's why she was still around, because her I have left message didn't start hitting until yesterday. Okay, interesting. One last pound of flesh. All right. Hello, Ms. Williams.
Good morning, Judge. How are you?
I'm well. Good to see you. So Mr. McCallman, I think is your one case from this morning.
Yes, Judge.
We had a very long talk. He was live from Ohio.
Okay.
And he has been given until May 5. He's going to be on a calendar on May 5, and he either is showing up in person all the way from Ohio to meet with the public defenders, or someone will have filed an entry of appearance on his behalf before then, and then he can zoom in from Ohio and we'll see if that person's waiving arraignment for him. But we heard a lot about his financial situation and the steps he's taking, and we agreed, all right, May 5, you got to come all the way back here if you don't have a lawyer, as a way to prod him to do that.
Okay, understood.
And that's it. So still no waiver of arraignment. We're still waiting, so he'll be on that. There'll be a clean arraignment calendar, hopefully with a lawyer attached to him.
All right, sounds good. Thank you, Judge.
You bet. Ms. Smith, let's talk about Mr. Peoples, if we can. So there's Mr. Peoples, and there is his lawyer, and there we go. All right. Ms. Rivers, good morning.
Good morning.
Is your daughter's tire all better?
Yeah, she has a brand new tire. She's on her way.
Excellent. Well, I'm glad you were able to assist. We're going to handle position 7 from this afternoon's final plea calendar. And we'll get on the record for that. It's 25 SC 005 424, State versus Bradley Peoples. Mr. Peoples is represented by Mr. Irvin. Both of them are on Zoom. Ms. Smith is handling the case for the state. Mr. Irvin, I'm going to start with you. Have you received what you believe is all the discovery in the case?
Yes, Sean, we did receive it, and unfortunately, on my side, we received a document from our local public defender's office that corrupted our system. So I did ask Ms. Smith if she would kindly resend it again so I could download it again, because that particular server that we have, we had to discard it completely. So, but I did have it, yes, sir.
Okay. So you don't have concerns about, I mean, you have a concern that your server got corrupted, but not that the state's discovery was incomplete.
That is correct.
Okay. Ms. Smith, what is the offer for Mr. Peoples if he wanted to resolve his case today?
The offer in this case is 20 years to serve 10 with the balance prorated.
Ooh, okay. Mr. Peoples, do you understand what the state is offering right now? It would be 10 years in custody followed by 10 years on probation. So total 20-year sentence, 10 in custody, 10 on probation. Do you understand that?
Yes, Your Honor.
Okay. And is that something you and Mr. Irvin have discussed?
No, Your Honor.
Okay. Well, Mr. Irvin, you had mentioned there was something that you wanted to share or that you said the state was going to share. Was it simply that offer or what was it?
Well, the state extended the offer, but we're still in discussions in terms of going back and forth with it. That was the first offer, and I've made a counter offer, so we're in the process of discussing it. That's basically what I wanted to go on the record with. I'm sure the state wanted to go on the record as well with their offer. We're rejecting their offer, but we are in the process, like I said, of going back and forth. Hopefully, we can reach some type of happy ground with this.
Got it. I hope there is a middle ground. Where we are right now, Mr. Peoples, hey, do you live down in Savannah?
Yes, Your Honor.
Okay, good. Mr. Irvin has explained on your behalf that you're rejecting that offer, which is fine. That's your decision. The only thing that changes after today, you can still enter a plea between now and your trial. You're going to be on a trial calendar at the end of April, so a month and a couple weeks. And you'll need to be here for that trial calendar. It's an in-person thing, so you'll need to travel from Savannah. Between now and then, you guys may work the case out and come on in for a plea. After today, the one thing that changes is that if you do enter a plea, you are not able to withdraw it if you don't like the sentence I give you. And let me give you an example. Let's fast forward to the beginning of April. Mr. Irvin has negotiated something with the state and you come in and Mr. Irvin recommends a sentence of 5 years to serve 2 years. And I'm making this up, but let's just say that's what it is. 5 years to serve 2 years. And I hear more about the case and how a victim was injured in this case. And maybe I learn about your criminal history and you may have no criminal history, but pretend you do. And I listen to all that and I say, you know what, Mr. Peoples, actually, I think the right sentence is 4 years to serve, not 2 years to serve. That would be your sentence and you could not withdraw your plea. Today you could, if you decided to enter a plea and Mr. Irvin recommended 2 years and the state recommended 10 and I went with the state's recommendation, that's a whole lot more than what Mr. Irvin recommended and you could say, no, thank you, and back out. After today, if you enter a plea, you're stuck with whatever sentence I give you. You understand that?
Yes, Your Honor.
Okay. Just like if you go to trial, if you go to trial and a jury finds you guilty, you don't get to say no thanks to the sentence. Your sentence is whatever you get. But of course, Mr. Irvin will be advocating on your behalf throughout it all, and he may argue for something different than what the state recommends. Between now and the end of April, make sure you stay in touch with Mr. Irvin. He is going to be working closely with the prosecutor to see if he can get you a different offer from the state. And if it reaches a point where you want to enter a plea, either because it's negotiated, both sides agree, or non-negotiated, you're not too far apart and you want to go forward with it, then we'll get you in court and we'll handle that plea. Otherwise, I'm going to see you on April 23rd. That is the trial calendar call. And like I said, you'll need to be here in person for that, just as will Mr. Irvin. Mr. Irvin, any questions about anything in the case?
No questions, Your Honor.
Ms. Smith, will it be easy enough for your team to resubmit discovery to Mr. Irvin?
Yes, Your Honor.
Great, thank you for doing that. Mr. Peoples, any questions before we sign you off?
My particular case, it was really a case of self-defense.
Okay, don't talk to me about the facts of your case. Mr. Irvin's not going to want you to be talking about that with the prosecutor listening. I just wondered if you had any questions about process, about what's going on.
I was going to ask, is that what we're going to discuss on the next court date?
So you and Mr. Irvin are going to discuss all sorts of things like, hey, if we go to trial, what's our defense going to be? And what are the risks of going to trial? And does it make more sense to try to enter a plea? When I see you on the 23rd of April, I'm simply going to be asking your lawyer, have you resolved the case? And if not, are you ready to go to trial? And hopefully the answer is yes, because this has been rattling around for a while. You got arrested back in June of 24, so we're coming up on 2 years. And it's time to get closure for you and for the alleged victim in the case. And that's my goal with that April trial calendar, okay? All right, Ms. Smith, anything else from the state?
Nothing further, thank you.
All right. Well, Mr. Irvin, thank you for dialing in. Mr. Peoples, you do not need to dial back in at 1 this afternoon. We've taken care of this. I will move your case to the trial calendar.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you, Judge.
All right. So we got through calling this morning's calendar. We're waiting on Ms. Cabrera. And I think, Ms. Wood, you needed to speak with some people. So why don't you do that? I'm going to talk with Mr. Hines and Ms. Smith while you do that. So, Mr. Hines, good morning.
Good morning, Your Honor. Please forgive me for being a little sorry.
That's all right. Ms. Scott said you were on your way. And as you could see, we've been handling other things. BHTC did not work out for Ms. Scott. She is low risk, and that's not who BHTC works with. So we need to know what else is next, or what is next with the case. And that's why I had Ms. Nelson bring everyone in.
Yes, Your Honor. I received the state's new offer, which in candid to the court is a reiterated offer from before BHTC was on the table. I was supposed to be in trial yesterday. The case was dismissed, but Thursday, Friday, and this weekend I was heavily in trial prep. So I haven't responded to Ms. Smith. So if Your Honor would be inclined, I would ask for a, I guess, new final plea date so that we can have it worked out by then and maybe come to a resolution that we're both happy with.
So we've already had final plea and we were on a trial calendar. We took it off the trial calendar in the hopes that BHTC would work out, but it didn't. So the next stop would be the April calendar you just heard me mention with Mr. Peoples. So it would be to put Ms. Scott on the April 23rd trial calendar, not because it's necessarily going to be a trial, but at least we're backstopping it so that if for whatever reason you all haven't reached either a negotiated resolution or one where you're close enough together that it's a non-negotiated plea, then we can have a trial. I don't know that that's what anyone wants or that anyone needs, but I need to have the case moving in that direction rather than resetting it back to a final plea. We did that, we got to a trial calendar, and BHTC seemed to make a lot of sense, but for reasons I now understand, that wasn't the right fit.
Well, and Your Honor, it's caused a situation for the court, but I'm definitely, not displeased that Ms. Scott was found to be low risk. That's just a testament to the work she's done since these allegations.
Oh, no, it's a great finding. If it was, we don't have the ability to treat her, in other words, she's too high risk, high needs, that would mean we're moving in a very, very different direction. So it was disappointing in that you all maybe had arrived at a solution, but I didn't view that as a bad development. It's a good acknowledgement.
We're just still working on it. So would we be able to present it? I think I heard you say we would be able to present a negotiated plea at that trial calendar.
So I'll have to check with Ms. Nelson. I don't remember if, hold on 1 minute. I don't remember if Ms. Scott rejected an offer and so the final plea has already happened, or if we preserve the final plea rights. But that'll be on the calendars that Ms. Nelson has. So if I preserved her final plea rights, they will remain preserved. If I didn't, then they won't. I don't know much about this case, but the way you and Ms. Smith have been working together, it strikes me as a case where people aren't going to be all that far apart. And so the final plea rights are less essential than maybe the preceding case where the state's offering 10 to serve. And my guess is Mr. Irvin's going to say some lesser number. And so the passage of those final plea rights is pretty significant. I don't know that that's this case, but I'll abide by whatever I said before. I just don't remember that answer. Ms. Nelson will have memorialized that on the calendars.
Yes, Your Honor. And just off the top of my head, is the 23rd a Thursday?
Probably. We often call calendars then. That won't be when trial starts. That'll be, it is a Thursday. That'll be the call of the calendar. So everyone shows up, and that's sort of your last chance to work it out. Because if you don't, then I know these are the 3 cases left. And we agree that next Monday, I'll see you and you and you, and we'll see who goes to trial.
Yes, Your Honor. I'm set to be in trial in DeKalb for a specially set murder from the 13th through the next week, which is, I think, ends on the 24th.
Mm-hmm.
I don't know, I mean, except for jury deliberation, if it'll go that long. So I can definitely be in touch with Ms. Nelson with the appropriate conflict letter or whatever the case may be.
Well, 2 things about that. Ms. Scott will still need to show up. There's no reason if you and Ms. Smith sort something out, we can't do that before you start your specially set DeKalb murder trial. That's another reason to jump on this one. And you're here and Ms. Smith is here and Ms. Scott is here. So I'd hope before you go, you guys talk some more about what alternative might be. And it sounds like Ms. Smith has said, here's the state's suggestion. And if you have some counter offer or mitigating information, it's a great chance to have a face-to-face since everyone's here.
Yes, Your Honor.
Okay. Ms. Smith, is there anything you want to add about Ms. Scott's case?
No, Your Honor.
You're ready to go whichever way it goes?
Yes, Your Honor.
Okay. Ms. Scott, do you have any questions?
No, Your Honor, I wasn't really pleased with not being able to get into those cases, but I believe whatever is most fair option.
Okay. Well, I'm with you. I was excited by that as a potential solution, but it's not a knock on you. In fact, what they concluded was that you've achieved a certain level of stability in your life that we have limited resources with the accountability courts. And so we try to apply them to folks who most need it. The conclusion was not that you wouldn't benefit from more support, but you were in a much more stable situation than other people who were applying. So like Mr. Hines said, it's sort of good, bad news to get. All right, well, I'm gonna ask you to stick around while Mr. Hines has a chance to talk with Ms. Smith. And then if anything changes, you guys can let me know. Otherwise, you should feel free to head out after you've engaged with Ms. Smith.
Thank you, Your Honor.
All right, thank you. All right, I'm gonna come back, Ms. Wood, when you're ready with a couple of yours, unless there's something else we can do right now.
Judge, I'm on.
Oh, Ms. Cabrera's on, but yes, Ms. Wood, you were gonna say?
Ms. Armour, we connected, she had a good address on file, she through today, I've gotten number and state of mind, and I'm just gonna file a waiver today.
Okay, Ms. Armour, let me look up your case. So you will do a waiver, you said?
Yes, sir.
Thank you.
There you go.
So Ms. Armour, you live in Chattanooga? Yeesh, okay. Going forward, make sure you check with Ms. Wood because it may be for other court appearances. It's okay for you to appear via Zoom, so you don't have to come all the way down here. And she'll let you know. I don't mind if we're just having a basic conversation. If it's something real substantive and you might have witnesses testifying, I'll want you to be here. But otherwise, I don't mean for you to come all the way down here if it's going to be not a major event. Your bond order hopefully says it's okay that you're in Chattanooga. You are not supposed to have any contact with Mr. Ashley. Have you been maintaining that? No contact. Okay, good. And you're not supposed to have violent contact with the police. Hopefully you're doing that. And that's really it. Are you working or are you a student? Both. Where do you go to school? Pardon me?
No.
Okay, and what do you do for work? Okay. Well, you sound like a busy person. Stay in touch with Ms. Wood. She'll let you know what's coming next with your case. She's going to get the discovery in your case, so police reports, maybe body cam footage, things like that. And then she will let you know what's happening next, okay? All right, if you don't have any other questions, you're good to go. You're welcome. Mr. Ashley, Ms. Cabrera is on the call. She may end up being your lawyer. I'm going to tell her about your case in a minute, but Ms. Wood has determined she's representing Ms. Armour, so we'll be getting a different lawyer to represent you. We can't resolve that today. All right? Ms. Cabrera, good morning.
Good morning, Judge. How are you?
I'm well. Good to see you. Where are you calling from today?
I'm in Cobb County,
In Cobb.
just outside the courtroom.
Great. You have one for sure client and maybe a new client, but we'll work through Mr. Luemba or whatever we need to do. The for sure client is Mr. Fagan, who appears on this calendar about 9 different times.
Yeah, and that's what I wanted to, and I'll go through, I think Ms. Nelson has emailed us a calendar. I have to confirm that all of the cases are actually mine, and that I'm not sure of.
Okay. Well, I'll make sure if you work with Ms. Nelson that you get all of the case numbers. He has 2 that are consecutively numbered that you're listed as his attorney and you filed an entry and a waiver. So I'll mark that down. Waive for the case ending in 125.
Okay.
And you did the same in 126, so those are covered. And that's Cabrera.
I should have one that ends in 178.
Yeah, I'm gonna get there. He was on for a revocation, but that's already happened. So that's good. And then he had, 178. And that's it. Those are the 3, plus there was that revocation. But like I said, the revocation has happened. So we don't need to worry about that. So I think you've got all 3. Did you do, the one ending in 178 is old?
It is.
Had it already been arraigned or
I don't remember, but I imagine so. I'm just looking at, it must have been arraigned because the one on 178, I got a scheduling order. For.
Oh, right. And then he disappeared on us. There was a bench warrant in May of last year for final plea.
Right. And that scheduling order was done back in February of 2025. So he had an arraignment on that one for sure. Okay.
So what we'll do, is Mr. Fagan here? Yes. I'm gonna bring him out in just a minute, but just so we walk through this, you did the waiver back in January of last year. You're right, there was a scheduling order. My suggestion is, if you're all right with it, is that we do a scheduling order for the 2 new cases. Looking at the charges, they don't look real complicated, so we could have it be a kind of accelerated scheduling order, the main part to be getting you the discovery, but we tap the brakes on what I'm calling the gang case, that's the older one, so that these other 2 catch up to it.
Okay.
Does that work for you?
Yes, it does. And then hopefully we can get some sort of I'm pretty sure whatever happens with the gang case is going to control what happens to the other 2 cases.
Okay. Ms. Smith, are you handling all 3? I know Mr. Abadi is here and he said he was prepared to talk about the gang case. It's got your name on the calendar.
For position 4 on the clean arraignment, that is my case. Position 5, that'll be ADA Willingham's case.
Oh.
And then for the one that's on the inquiry calendar, position 4, that'll be Mr. Bobby's case.
Why have 1 prosecutor when you can have 3?
I'm gonna have it.
Okay. All right. It sounds like to align up a global resolution, Ms. Cabrera, you'll want to work with Mr. Abadi. And to your point, the gang case, the older one, which is Mr. Abadi's, that would be the one that kind of dictates what happens with the other two.
Okay.
So I'm gonna leave it to the state to figure out who's gonna send you discovery in the 125 and 126, but you'll get that. And then please work with Mr. Abadi as you think about an overall resolution.
Okay.
Do you know, are there any unindicted cases for Mr. Fagan, or is he basically being held on a bench warrant in the gang case?
I think he's being held just on the bench warrant for the Yankees, I can check.
Okay. Can we bring Mr. Fagan out to the podium, please? Have you all met before?
Once upon a time, I think.
Okay.
But
We'll see if
it
you
was
recognize
like,
him.
yeah.
Yeah.
It's over a year ago.
Yeah, he's got no unindicted cases, John.
Okay, great.
So it's just the 3 cases.
Yes, ma'am.
Judge, is there also a Centol burst on this calendar too?
There
I got a
is.
notice in the
We'll
mail.
get to him in just a sec.
Yeah.
Good morning, Mr. Fagan. I'm all right. You come right up to the podium there. Hey, I'm Judge McBurney. I've got 3 cases with you. And I was just talking with Ms. Cabrera. You can see her on the screen. That's your lawyer. She worked with you way back when on your oldest of the 3 cases where you're charged with a gang offense. More recently, you've been indicted for things that happened around Christmas time of just this past year. And so you've got 2 cases. Ms. Cabrera is going to be handling those for you as well. And I was just catching up with her as she was getting up to speed and figuring out which prosecutors can handle all those. So Ms. Cabrera is going to get discovery in the 2 new cases as well, and then connect with you to talk about what do we do? Do we try to resolve all 3? We go to trial on one? Is there a motion to suppress in one? But she'll talk with you about that and then let me know what do we do next to move your cases along. All right?
All right. Can I say something?
As long as you're not talking about the facts of your case, you certainly can say something.
I took a year for probation violation. Do you think they're gonna send me down to prison and not finish this, or am I gonna finish this first?
So, great question. 2 things. One, I know Ms. Cabrera is going to try to see you soon in case you do go to the Department of Corrections. But even if you do, we don't forget about you and we don't stop working on these cases. We will patch you in via Zoom if it's a simple conversation. And if it's more involved, I just do a production order and bring you back. So I don't know the answer to that. That's a sheriff and Department of Corrections conversation. A year revocation typically means that you go to the Department of Corrections, but it doesn't always mean that. But I appreciate you flagging that because that's a reason for Ms. Cabrera to come see you soon. You're a lot easier to see. Are you at Rice Street? At Rice Street than you are in Valdosta or wherever you may end up. But we will not lose sight of you. In fact, I just talked about entering a scheduling order that will move your 3 cases together and quickly. So if we need to bring you back, we will certainly do that. Or if we need to keep you here because we're about to work them out, I can do that as well. That's an important thing for you and Ms. Cabrera to discuss when she connects with you. All right?
I would like y'all to discuss, try to keep me here, 'cause I don't want to go down there and have to come back when I'm done. I gotta go to 2 different counties after that.
Oh, you have other counties to hit. Where else do you have to go?
Clayton.
Okay, you would go there before you would go down to the Department of Corrections. So you'll stay close. It may be that you leave Fulton, but if you do, it would only be to go to Cobb or Clayton. And so you're just going to want to keep Ms. Cabrera posted so she knows which of those to hit. Okay? All right. Thank you.
Thank you, Judge.
You bet. Do you want to talk about Mr. Burse?
Yes, so Mr. Burse, is Mr. Burse present? Is he in custody? He was assigned
He's here.
back in
He's not. He's here now.
2000.
Okay.
He was
He's here.
He was, yeah, okay, so he was assigned back in 2024, and then I don't know what happened after that. but he had, I had the case ended in 595. And then Ms. Nelson contacted us on, I think March 2nd to ask us about a new case that he has. And the new case that he has was given to me on March 8th. So
Okay.
I do have that one now.
Oh, 595, look at that. So the one that's on the calendar is a 24 SC case, and you've got that. He missed court also for a final plea, but a month earlier than Mr. Fagan. And in this newer case, the 595, it just got sent to us from Judge Farmer because of this older open case. So did you say you will have it assigned to you, or you don't know?
No, I do. I got so she emailed me March 2nd. We didn't have it March 2nd, but we did get it March 8th. So we do
Got
have
it.
it
So
now.
it's brand new to you and to me.
Right.
And you'll be handling that. Okay, great. Oh, and I see it's listed as being on for plea and arraignment today. Okay, well, maybe we can knock
And
out both.
I can submit a waiver too.
Okay,
The
great.
form that you use.
All right, well, we'll bring them out right now.
Okay. Do we know who the DA will be on both of his cases? Is that Ms. Smith?
Yes,
I'll be in touch with you. I'll shoot you an email.
great. Mr. Burse, good morning.
Good afternoon.
I'm Judge McBurney. We probably met a long time ago. You have an older case and you got a brand new case. And we're here to talk more about the new case. I have on the screen Ms. Cabrera, who is your lawyer on both cases. She worked with you back in the day on the older case, which is marijuana, and you allegedly had a gun. The newer case charges you with aggravated assault, and it was indicted just a few weeks ago, got assigned to a different judge, but because you had the case with me, we try to have all cases with one judge, so you have one lawyer, one judge, one prosecutor, all that. So Ms. Cabrera is going to be handling both cases for you, and I'm going to ask her in a minute if she's waiving arraignment or not for you on this new case, and if she is, we'll get a scheduling order in, the prosecutor will get her discovery, and we can bring back to life your old case and have it move along with this new case. It makes a whole lot more sense to try to resolve everything together if they're resolvable. I don't mean to say they are. It may be that you should go to trial or the state should throw the charges out. But Ms. Cabrera will help you process all that, okay? All right, Ms. Cabrera, are you waiving arraignment in the 26 SC case?
Yeah, sure. We're waiving formal arraignment and entering a plea of not guilty.
All right, and you'll get that waiver form to Ms. Nelson. I'll get a scheduling order out. Ms. Smith will get you discovery in the new case. I assume you still got your case file in the old case that got put on hold when we couldn't track Mr. Burse down.
I'll check. I don't have a note on here that says when that discovery was received. Usually I write that down, but I'll check.
Okay, let me see if there's anything in the docket about, it got to final plea, so hopefully discovery was produced.
Yeah. Usually I just track when they send it to me because depending upon how they send it, there's a date that it expires. So I like to keep track of that usually.
Got it. Yep, that makes sense. And that was pre-Ms. Smith, so I can't vouch for the reliability of discovery going out or not, but.
I'll send her a message and find out.
Great. Okay. Yeah, check on that, and then we'll just have the two cases moved together. Mr. Burse, so today is really just this formality of letting you know I have both your cases now. More importantly, Ms. Cabrera has both your cases, so you've got a lawyer working on your behalf. She will get that discovery and then figure out a time to meet with you to talk about strategy, next steps, et cetera. And then I'll see you either because Ms. Cabrera has filed some motion or motions on your behalf, suppress this, do that, or because you all have sorted something out, and then we'll get you in here and see what that looks like, okay? Sure. Any questions?
No, that's all.
All right, Ms. Smith, anything from the state?
No.
All right.
Thank you, Judge.
You're welcome. So I think that is it for your cases. Yeah, if that took care of Mr. Fagan, and then I don't think you have anything on the final plea calendar this afternoon. So you are released to Cobb.
All right, thank you, Judge. If something happens, I'll be here. I got 3 courtrooms here.
Oh, one last thing. I met a friend of yours who rides bikes with you, which was hilarious because this dude, he's still built like a linebacker. I mean, he looks like he weighed 280 and like no bike would support you and you don't look like a bike. You look like you would throw bikes rather than ride them.
Yep, he is like a freight train. He used to play for the Baltimore Ravens.
Yeah, right.
Really good friend of mine. He sent me a picture. He took a picture with you. And
Yeah, we did a selfie. I'm sending this to her. I'm like, all right, you do that.
Yeah.
That was funny.
That's my buddy.
All right. Well, take care.
Thank you, Judge.
Bye-bye.
Bye-bye.
Ms. Wood, anything else cooking from the plea and arraignment calendar? Yes.
I just sent a change of address to Ms. Nelson. I'll get a waiver file today.
All right, Mr. Hill. Hey, let me pull up your case. So the Morgan Road address is the old address? Okay, and whatever a good new address is, you've given to Ms. Wood. Great, that'll go in the system because the official notice you get comes in the mail from the clerk of court to whatever address you share with us, which right now is that Morgan Road apartment. It'll change. The unofficial notice is the one that will be much more effective, and that'll come from Ms. Wood. She'll text you or someone on her team will call you when you need to be in court or when something's going on. So make sure if for whatever reason your phone number changes, you let Ms. Wood know that.
And then a couple months ago, we'll change the address just to make sure I got it.
Okay, I believe you, and I believe that it didn't work. And hopefully it works this time. More importantly, Ms. Wood is saying, look, I'm telling you, his address has changed. So you're on the record of saying, hey, it needs to be something different. Only other thing I want to cover with you is bond. You are supposed to have no violent contact with a Ms. Bridges. Do you know who Ms. Bridges is? That would be Ms. Bridges right there. Well, don't have any violent contact with her. It's been okay so far? Okay. Pardon me? Okay. All right. That's the main condition of your bond is be nice to Ms. Bridges. Ms. Smith, is this going to be a Willingham case?
It is, Your Honor.
Okay.
Her only announcement for this case was that she would be offered out to Ms. Wood by the end of the week.
Okay. And hopefully discovery if it's not already out there. Yeah. All right. Great. Then that's it. Ms. Wood, anything else? Mr. Hill, you are free to go. And Ms. Wood will let you know what's happening next. All right. Oh, Mr. Ashley, I blew it and I let Ms. Cabrera go, but I'm going to let you go now. 99 times out of 100, Ms. Cabrera is the conflict defender, and so she will likely be your lawyer. Every once in a while, they assign it to someone else, but she doesn't make that call anyway, so she would have just been able to say hi, but not guarantee that she's the lawyer. I want to confirm your contact information so that when we figure out who that lawyer is, we're able to provide it. So give me a second. You also are in Chattanooga. Okay. How close do you live to Ms. Armour? Okay, that's good. Chattanooga's big. Stay away from her because she's supposed to stay away from you. You're on Dayton Boulevard? Okay, so we've got a good address. I don't have a phone number, so if you would, Deputy Gordon's going to give you a note card. If you would write down the best phone number for you, your cell, mom's cell, whatever's most reliable, and put your name on the card, we'll make sure we get that to the lawyer, since you are in Chattanooga, it's likely that the first contact is going to be that phone call and not showing up at your door because the lawyer is going to be based here. All right, and once you've written down that number, phone number with your name on the card, and write it legibly, then you're good to go. And we're going to get you a new notice of when to be here with that lawyer. But you should check with Ms. Nelson, that's my litigation manager, about appearing virtually. For arraignment, virtual appearance is fine. I've laid eyes on you. I don't want to make you trek all the way down here for what would be, we waive arraignment for Mr. Ashley, and then that's it. So please do check with Ms. Nelson, and she'll likely say that you could just be on Zoom. Okay? Mr. Dodds is still not here yet?
He's here.
He's here. You need me to go away to bring him up?
5 minutes.
Okay, hold on. Let me just see what else is going on. Artie Lidecker, still a no-show. All right, bench warrant. Then we've got, can you bring Mr. Conley to the door? And then we'll take a quick break so you can get us Mr. Dodds. Mr. Conley.
Good morning.
How are you?
Fine.
Mr. Conley, when we last spoke, good morning to you. When we last spoke, you shared that you were planning on hiring a lawyer.
Yes, he already been retained, gave him 500. He's saying he want 1,500 more to take all 3 of my cases since the public defender don't want to be on my probation case anymore. So that being said, my money is tied up, so I can't just give him $1,500 right now, sir. Okay.
Well, let me look this case up. Are you saying that the lawyer already filed an appearance, or you're not sure?
Not sure.
Okay, well, let's.
I gave him a $500 payment.
Yep. Okay, yeah, and that's not Mr. Olaloye. That's not who we're talking about? You had a lawyer named Olaloye. That's who handled your case when you pled back in 23.
Oh, no, not him, it's Mr. Toller.
Okay,
Toller.
that's what you told me. All right, so when we last spoke, you said it was Mr. Toller. So he's taking some money, but he said if you want me to handle everything in a.
All 3 of my cases, he said he want 1,500.
Okay. 1,500 total or 1,500 more?
Yeah, 1,500 total.
Okay.
It's gonna be 2,000 total.
Got it. Okay. You said one thing that I'm confused about. You said the public defender doesn't want to handle my revocation.
She said she wanted to come off my case because I have a paid attorney for my gun charge.
Okay.
She was like, well, you might as well let Mr. Toller take all 3 of the cases. I don't feel like she represented me to the best of her knowledge anyway.
Okay. Well, it sounds like you don't want that situation anyway then, but I remember it a little differently.
Just offered me 2 years, she ain't.
Well, my guess is what happened, but I don't want you to talk about your private conversations with the lawyer, is that she said, this is what the state is looking at doing. And so if you want to do that, you can, or we could have the revocation hearing, like a mini trial, and see what happens there. So I don't have a gun, I have a theft by shoplifting case, is one of your unindicted cases. And the other one, yeah, oh, okay, there was a gun, okay, it was a, so you had something funky with your license plate, it must have been stopped, and then there was a gun in the car. Got it, yes. So Mr. Toller's not listed as your lawyer in any of those. Tell me what you want to do. You want to figure out a way to untangle the money so you can get more to Toller? Or do you want me to, if you're not able to afford him, you can try to afford someone else, or I can appoint a lawyer to represent you. But you don't seem real enthusiastic about that.
Yeah, because the last attorney just, she didn't even say good morning. She just said, we off for 2 years. Do you want to accept it or not? And I was just like, no.
Okay. No is an okay answer. So tell me what you want to do. You want to try to sort things out with Toller? Because if you're not going to have the money, you shouldn't be stuck because you don't have the money. That's not how.
It ain't even that I don't have the money, because I have the money, it's just, my money gotta come in the check form. My taxes come in the check form, so I'm waiting on it to come.
Okay. And is that your preference, is to wait till you get the money and get Toller on the case?
Yes, sir.
Okay. When, I don't want to have your, go ahead.
I'm saying, so today, could I deal with it today?
So let's ask Ms. Smith. Ms. Smith, has the state's recommendation in Mr. Conley's revocation changed?
No, Your Honor.
So it's still your recommendation and probation's is to revoke 2 years?
That's correct.
All right. So what could happen today, Mr. Conley, is that Ms. Wood, who you've not spoken favorably of, could advocate for a sentence of less than 2 years. She's not required to go along with the 2 years. She shared with you what the state's recommendation is and what probation's recommendation is. The discussion would simply be, is 2 years reasonable or should it be lower? It wouldn't be about the facts of the case. If you want to fight the charge, which you're entitled to, then the state actually has to prove up the situation with the license plate and the gun. They have to call a police officer, whatever it is, and we have a hearing. It's not with a jury, it's a bench trial, and the burden of proof is a lot lower for the state, but they still have the burden. They got to prove it. They don't just get to say, hey, he had a gun. An officer or officers or an eyewitness or whatever would need to come in and testify. We can do that as well. That we cannot do today. It was on the calendar today either because you guys had worked something out, or to figure out, are you bringing Toller in, or do you want to plug back in with Ms. Wood? So yes, you could work it out today, but the state's going to still recommend 2 years. Ms. Wood will recommend what you and she think is reasonable. She may say time served, which for you looks like it might be a little less than 3 months. And she can say that, and I'll listen to it. Doesn't mean I have to do it. I may agree with her. I may agree with the state. I may say, this isn't so serious. I think 6 months, but I don't know. I've heard nothing about it. So that we could do today, but you run the risk of it being 2 years because the state's recommending 2 years. If you don't like dice that look like that, then you should either engage with Ms. Wood and say, I want the hearing. They need to bring these officers in, or tap the brakes and say, I want to wait on Toller.
I haven't talked to Ms. Wood since
Okay.
I've been incarcerated. Only time I talked to her was when I came to court the last time. That was 2 months ago. So I don't know how she feel. I don't know.
Well, she didn't go to see you, so you know, because you told us I'm hiring Toller.
I'm
So,
talking about even before. I've been working there since December 21st. I
okay,
haven't seen this lady since
okay,
January 27th.
got it. And she wouldn't come see you after that day because you told us all you're bringing Toller in. No other lawyer would come see you because you said I'm hiring this other guy. And so lawyers are supposed to back off. So she did what she's supposed to do. But I'm not foisting anything on you. You need to decide.
So moving forward, so if I do move forward to that,
Yep.
2 years or
So if you move forward today, I would ask Ms. Wood to have a conversation with you. So you could say, look, let me tell you all about it, because it's a confidential conversation. You could say, you need to share with the judge this, that, and the other thing. She'll give you her thoughts about what a sentence is. She'll give you her thoughts about what I might do. She's in this courtroom all the time, and she could say, McBurney is a softie. McBurney can't stand guns. McBurney never has a license plate, so he'll be sympathetic to you, whatever the deal is. She'll give you her thoughts, and then she'll advocate for you for a sentence. But all we would be talking about today is which sentence is more reasonable. It wouldn't be, well, the state didn't prove it. But you have a right to have the state prove it. And if that's what you want to do, we don't need to wait on Toller. I'll set this down again a few weeks out. The state will need to bring a witness or witnesses to see if they can prove it up. Ms. Wood would represent you. She'd cross-examine the witness, and then she'd argue the state proved it or didn't prove it. That would happen likely sooner than you get Mr. Toller. But you've got these two other cases, and you may want to have one lawyer for all three of the situations. That's your prerogative.
I feel like it was no reason for her to just throw Mr. Toller onto my probation case. she didn't have anything to do with it. Well, Mr. Toller didn't have anything to do with my probation case. She's supposed to be my attorney for my probation case. I understand that, but I went to hire Mr. Toller for the gun case and the shoplifting case.
So we may have had a misunderstanding then, because what I understood you to be saying was that after we had our conversation, that you wanted to have Mr. Toller handle all three. And I may have misunderstood that, but
She said, Your Honor, can he just handle all three of the cases? Can he just take the probation case too?
Yep.
That was her.
okay. Well, regardless of who said it, what I took from it was that Mr. Toller was going to be your lawyer.
That's why he wanted more money.
Okay, got it. And so now we can unwind that. If you don't want to figure out how I'm going to get this more money for Toller and I want to sort out this revocation thing, you can. You'll be working with Ms. Wood if that's what you're going to do.
I want to see what she's talking about now.
Okay.
They're trying to come down.
All right. Then I'm going to have you pop back there now that you've cleared up that, hey, Toller is for these unindicted cases. I don't have the money for him for this revocation. Then in a minute, I'm going to take a break. Ms. Wood can talk with you about it, and then you guys can let me know what's going to happen. Okay? You bet. All right. Anything else before we take a break so that we can bring Mr. Dodds up? Ms. Smith, you good?
Yes.
Ms. Wood, you excited? Mr. Hines, probably because I've kept Ms. Smith busy, you haven't had a chance to talk with her?
Yes.
Great. Your opportunity is about to approach. And Ms. Rios, we're glad you're here. I know you got something on the calendar, so we'll get to that. All right, let me know when everyone's ready. Please. A lot of talkative people today.
Oh, is that easier way? You guys, okay. Okay.
I'm leaving. I need to talk to Mr. Abadi.
Oh,
Can I see you for a sec?
yes. I'll say anything about it, you don't list.
I have a guy who he kept saying he was going to be on
Well, no, I think Jess went to bring out. I already get my favorite green today. I guess. I know Jess is on top. I know, it's especially.
Yeah, he wanted to introduce himself.
No pillow she's right. Okay, still not.
Is she in school, employed?
So she is.
How can you do that?
She's all right. She's having a job.
Oh, you're good, you're not my seat.
In her field.
Yes, so. Okay, so tell me a little bit more.
Yeah, we're good.
I had heard that version was when I was in the court, like, it was like, are you serious? This is really interesting.
Left us all high and dry.
Okay, so.
So this. She's like,
Well, she's doing great, because she really, she just steps in. Like, man, she's like,
Exactly, that's a dying breed.
right.
This
Let's
is
do
new
it like
ones,
that.
this new groups. 3 cases.
Yeah.
And you quit overwhelming. I want me to do what if I'm lost?
Right, and I mean, it's always a shot.
You don't really, see, that's what use the few of us that go, I talk about, with the calendar, we're done 60 people.
Correct.
And you're supposed to be this, roll this stuff out. We go to get it. That version is you might know like that. I would want to myself. What I can do is.
Because it's easy to let you deal with that.
They still care.
And then it's good. It's even easier. That's not happening. Which one?
There was a recent meeting where I had this provider on the dispositions for its treatment. She made a charge. I called that. That's a. I did, so the person at the office taking just now, it's like 10 years ago.
Right.
Like, also I people who think them 10 years. I can't even know. So I did a charge, I sent her office, it's been 3 years. It was 3 years, 3 kids have gotten first.
Yeah, I think that's heard of it.
Right.
I heard they love that.
I'm gonna have James, one's getting ready to change.
So when we fought, well, I'm sure that there's some matter case of your dad, where you got the mandatory minimum.
Hopefully you never know.
To show you doesn't turn by grade.
Oh, yeah, I get the letters.
And because it
I know he has
was
quite
mandatory minimum, you can't, you have no discretion. Make up that running breeze.
Oh, so we were part of, I don't, it was such a long time ago when we had the hearing, it was, I still have to, because that changed everything.
Yep.
It went all the way.
Yep.
Timothy, it's not Timothy.
I think it is. I'll ask Kevin.
Yeah, I have the, I still have it, I keep it, but she did, she let it out early. And the whole thing, he has been having to go back to custody, but it was like 3 years later, by the time it was, Timothy Hudson.
Hudson, yeah. I knew it was Timothy.
Yeah, Timothy Hudson. Yeah.
So.
Yeah.
I was gonna say about the.
I love her.
Yeah, hopefully, like I said, we,
When she treated you.
oh, but he has done, that's, cause I can testify, that's not what I do, and I was like, yeah, he was on the honor student. I didn't want to make it, sometimes I look at this transfer.
He was, everybody else.
It was, that was like.
I was like, mine was less us.
Yeah.
The very first part.
Yeah.
So I came over and that's it. All right. See ya. Happy whatever day to. You all right? Now they're taking over for turning one.
Yeah, he did that for me. No, that's a juvenile case. Is it revolved? It was a obstruction.
Yeah.
That's it.
Yeah, he's over his knees.
Casey, that's it. I'm in all of them. Yeah, I have to be at all of them.
He can do it if he can do it.
Yeah. I believe it's denied. It wouldn't have been, because usually.
Yeah, sure.
I believe, because that was in front of judge.
Oh, yeah.
It's on the denied to do.
Yeah.
So. Yeah, it didn't have anything else. So, yeah. Yeah, but well, I don't get them. So that they was okay, how many recommendations I made. What do you want? Yeah, this, typically, they have to use kinds of just setting aside the backside. Maybe you look at it. I don't even think they're not even doing anything with it, so. Because unfortunately, because that's something open like that. So. I'm really mentioning. No.
Oh, no, they would have been comfy.
Yeah. This week is out, so we have to. And then just probably next week. BHTC is on the American Closing. And very much more short. So. Definitely very, very close. I'll be coming back. Pretty nice. I can speak. I don't know. I think she had a little bit more right, but it's more than that. I'm growing that patience with us. You need to be something. What is more? Okay, I couldn't figure out the TLC. Yeah. I'm trying to figure that. I am.
So.
Oh, why?
It's in Chicago.
If you have, we're for.
Mr. McDowell. So. I think we want to.
Oh, I said, you guys come to the.
And started.
I said,
That's
you
the
guys.
Now, do I think that the.
I have a regular on the file.
Afterwards, you know?
Yeah. I said.
And so we're gonna try and faster.
Yeah.
It's being
I think
And I
that.
think it's probation. You got no criminal history, so.
I totally understand. I think the. Get it out your heart.
It's good to know how things.
I really want.
I got.
Cause she's.
There is a purpose for it. Taking out.
But when I walked in there.
The brain won't shut it from there.
And so I.
No, I
So I said, I'm not heard one case. And I was like,
But that's the offer I had.
what
It's gonna be
is this?
probated off
And I'm giving some.
with first to
They
fifth.
were like five.
And
That's
with-
very. And she's expecting to repeat.
You like the third or fourth person.
Yeah.
I just never know problem about that.
Yeah, we do, but.
When I'm in the case, I was.
I mean, I really never had.
Yeah,
that.
very good. It's very nice.
No, I mean, I usually write notes. I'll frequently confirm you out. I'm not sure.
Because he was so used to that.
Like, no, I can't.
All day. I mean, it's. And then the other one. I woke up, I said, "This is so much." I'm gonna go. Nobody got to say it's like, there's got to look at the thing.
That's what I'm saying. That's what I'm saying. You're still gonna be.
How was your weekend?
So my point is, I'm saying, if you know, if literally no know.
Oh,
That they're. I think it's actually.
And that's why I go, I have to respond, that's the first thing I
I need to file.
I think okay, I don't even make good. I just look at these, that's how. Well, that is, yeah, I got a shot, it can't be or cautious.
Before me, we had
Gilligan was when we talked to.
Yeah.
And then.
Good to see you.
So-
Good, all right. Thank you. Jimmy.
How you feeling?
Good, how you doing?
Good. Those are kids. I think.
I think.
She's in. I think she's in.
I would say maybe, but I just.
Oh, yeah.
This is China TV.
She's one of our customers. So, yeah.
No, we talked about motivation. I'm just saying.
That's how.
Somebody.
Yeah, because. Yeah, so.
I'm just gonna get it.
She got eaten, right?
Oh, killer.
The rest of all.
Exactly.
Really boss.
Big dog, I'm trying to tell you. Yeah. He already know it, but you got to boy.
All the time.
I ain't saying a lot,
He's trying to hide.
Man, look.
He's trying to hide.
No.
Oh, if, I mean, honestly. If we're doing like negotiating, I'm not worried. What I need in front of us.
Yeah, we just got a email from our chief, saying,
I don't plan on.
they were paying the bill, they're planning on creating another judge seat. But it's going to affect the judge.
No, I'm gonna call Gilligan. Now that's it, but that's what she can do.
Yeah, she said that, yeah, she said it wasn't for
Because.
But that's what we're going to go.
I'm really like a mini.
I'll get dressed. Wait.
I mean,
I was keeping.
Yeah, man. One day at a time.
That is like kind of last week because it was like, it was raining. It was just like, well, thinking about it. Seriously?
Was somebody was here this morning?
I was giving you the mild information. Like, but this is the same one? No, I didn't figure that.
I know.
Let me answer this person. Okay. Yeah. I wish I would have said.
No.
I didn't put that because I wasn't sure that they're fully in the name.
Yeah.
Yeah, no, but I mean, you don't want to get them this morning, get y'all, I'm trying to get y'all for his gym, okay?
Like he's
Telling her over.
Are you saying?
They are.
Yeah.
Okay. That they tell them what I'm talking about.
Because they would eat it. Now they can't do that.
Kid don't.
On a regular.
Yeah.
I deserve every one of them.
I never did. No, I didn't get. Yeah.
No, I didn't.
Watch all of us.
Often.
I'm trying to say road. And there was only 7 houses.
You have a
and
number
that's-
for these?
that's-
But I don't know about. But here.
Oh, okay, it's on time. Oh, they still out.
I mean,
It's like,
I still.
I'm looking at it.
Seriously, like you have it.
you wanna?
We can do his on, I don't know, his, no, his unprofessional certification. You can go ahead and handle that. Well, he goes to the
I think it's the blue, you got blue in there.
excuse me? Let's do, okay, when he comes back, let's change. No, I would bring out. I mean, Roger, we can talk to him, but I was, gonna be here all day.
3, 1, 4.
I'm not walking.
Okay. Alright. Task.
I like to get had it all.
968-282.
What is it?
968-282.
9, 6, 8.
282.
Oh.
Council statements.
I'll be right back. He's gonna look at it.
I see.
Today, for court.
Yes. Yeah.
I'm fine. Everything good?
Yeah, it's not.
I thought the paper.
Are we fine? Thank you.
You're welcome. We love you. I don't email you that much. Sorry about it. I don't give you email. Oh.
That's how it happened.
See, that's the, I'm giving you a paper.
That's been, that's how.
Because I don't give you a paper.
Making buildings, paying. To speak from them, and then look, count. They have so many. County like this, you know.
Oh, they fishing thing?
That fishing. I don't know who's, so I'll send that.
I ain't mad, look, I ain't mad at you because I went through. Done that before. I've done that before. It turned out to be different, but I'm like, and I have to go back. Send that back. I didn't recognize it, it looked fun, so, you know, I'm like.
You just can't talk.
See, no, you could, or you should like in her, cause.
So, every time you start a new
But that's how our conversation goes. I can't be, I can't my day, so. No, I'm glad I didn't see that. And I couldn't look at y'all and tell you, cause I was, I didn't know I was careful. First one, the camera was.
Right. This was, this camera right.
Yeah. Everybody's like, I tried my best not to. Yeah, I did. They don't like me. Oh, wow. Oh,
I didn't been on that.
Oh, somebody's looking. That was a handful. I don't know what they call it. No, they come in as my job. Where?
I gotta check.
What they did every time I was, yesterday, I was for sure. Let's see what we all was saying.
What happened with him yesterday?
Which one?
Was that motion?
But it's not.
It was a motion. He reserved. I had a probation. They came and stitches. Okay, that's what I'm saying. And I had to put them on the trial and then consolidate.
Wait, did another consolidate down now?
You got like 2 cases.
You Ryan.
Oh, I seen a lot of it.
Cause you're out.
I mean, the truck on the start yesterday, if you do that.
No, I'm just, I'm lying.
Oh, he.
You have anything on?
Huh?
No?
Huh? Well, I didn't get it, so I can't be on.
Maybe I have a speedy and I have the.
What's this bid? Supervisor Harris.
I did it.
Just like I said.
I don't think so.
It's 5 years, but don't send.
Murder.
And
That's the last thing.
I was in church in 2017. The person representing us, he just got me that. That's why I put it. He didn't have to go do that.
Why won't we take?
Okay, so he wasn't there. That's
Glad it's done.
bachelor's and.
We're not discussing that.
No.
Okay.
Okay, yeah.
Okay, I'll-
We have no
Seriously?
You know, that's all just.
That's even worse. So when I started here.
No one can like him. It's pretty, what's his history?
Because I guess.
First murder.
Well, I'm saying the thing is running around.
We should move those.
I know, right?
You wanna go back there?
And others.
Wait. Yeah, sure. Oh, yeah.
And you don't have to.
I think you're really murder.
not sure. I could have one. Most, Kelvin Moses.
Yeah.
Oh, is that okay? Yeah, that's work now. I might have.
There you go, bro.
Yeah, is that like we're ordering some
Takeout place. Yeah. Face is for you. Excited. How they go?
with that case, I was gonna try to resolve it today. Oh, here, right.
Oh.
I mean, you did a motion to set aside, right?
Yeah, that's true. It's just like, that's what it is. Look up, now see that. After this, so we're never gonna have a record for it, yeah. Then you don't close. You did like 2 years for the. We got to see.
Yeah.
I'm still waiting on some. They don't. I think the cameras on there.
Alright, see you folks on the water.
Thank you.
Robinson, yeah.
Judge Rand, excuse me.
Yes, sir.
Thank you.
Mr. Fortis?
Rich, how are you today?
I'm well. You're on for the afternoon.
I am, Judge, and I think my client is gonna get on Zoom, and if the court has some time, I'd like to make my announcement a little bit earlier.
Sure. If Mr. McWell gets on, we can, when we're in between matters, we'll do that.
That'd be fantastic, Judge. He should be on.
Hey, Mr. Robinson.
How you doing, Mr. Beverly?
I'm doing well. You can come on to the podium. This will be quick. I just wanted to say, hey, Ms. Rios is handling your cases. She's filed a waiver of arraignment for you, and we're moving them forward. And I just wanted you to know why you were brought over today. You had cases in non-complex. One got transferred and the other joined it. And we're going to figure out what we're going to do. She'll get discovery from the prosecutor or from her predecessor on the case if discovery was already provided when it was in non-complex. And I'll make sure that things move along at a healthy pace, okay?
You by any chance, Your Honor, you might have any idea when I will be able for your next court period? Because see, it's a total of 9 months.
You've been in custody for 9 months?
Been previously, 5 months before I got bonded out on this case that we in before, and then now.
We got 2 cases.
I got 2 cases, Your Honor.
Yep,
And
there's a stolen property case and a shoplifting case.
Right, and I found out since when I was incarcerated from March 21st of last year.
Yep.
It was dismissed, and then I found out how this true bill thing go about.
Yeah.
Okay, I understand that, right? But now that was 5 months. I didn't get a chance to get a bond until August the 4th.
Okay.
I was able to bond out. So now my attorney advised me now that these cases here are not what holding me in.
Okay.
Right, but however the case may be, I want to try to get them all resolved as we spoke about.
Okay.
But at the same time, you know, I'm in this. I'm like right now, 4 months back in here with no bond status. My bond was revoked, from my understanding, and here I am, and I was explaining to her my situation all the way around the board. You know.
Well, the good news is you have a permanent home now, meaning these cases are staying here. They're not going anywhere else. You got Ms. Rios working on them. She's mindful of the fact that you've been in for a while. She'll leverage that to your benefit. If the state is saying, well, I don't know, he may need to do some time. He's been doing time, and you'll get credit for all that time. But the answer to your question, I will see you next, either because Ms. Rios has filed a motion on your behalf to suppress this or that, or because she, after talking with you, has worked something out with the state and will be back here for you to enter a plea. If you're not interested in entering a plea, then we need to get you into court for a trial. I don't typically try shoplifting cases. They usually resolve. But if this is one where you're saying it wasn't me, or I paid for the goods or something like that, and the state's not budging, then we need to get you in here for a trial. And we'll do that. My guess is, though, what I'll see is that pretty soon Ms. Rios reaches out to my staff to say, can we put this on a calendar? Mr. Robinson's ready to resolve his cases.
Ready to resolve it now. That's what I'm stating to it. That's what I'm stating to. I'm ready to resolve this issue now, even without the PI, even without the other case. You know, I would take my chances on basically. Matter of fact, basically, Your Honor, sir, I've been feeling like I'm in a 440 relay. You were my 6th judge since I've been incarcerated on these cases.
Oh, it's more than a 440 then if you're on number 6.
So tomorrow, and then tomorrow you have, 60. I have another court date tomorrow.
For the PI case?
For the PI case.
Well, you got to stop getting arrested, Mr. Robinson. That's the deal. I mean, you can be flustered about you got these different judges, but you also got to do a little introspection and say, it's time for Mr. Robinson to stop picking up charges.
Taking accountability, I understand this.
Okay.
But I was explaining to her, you know.
Well, Ms. Rios, is it your professional opinion that you ought to get the discovery first so you have a chance to talk to Mr. Robinson rather than, hey, let's just throw it up and see what a plea looks like?
Yes, sir, and I explained to Mr. Robinson, and I was hopeful that we can get that PI case. I was actually just typing an email to send to Ms. Smith so we can get it all resolved in one time, because you're upset that you keep coming back, and I agree, let's get everything resolved so you don't have to keep coming back being done.
In fact, so you know, Mr. Robinson, when I learned that it was going to be Ms. Rios handling your cases based on the older of the 2 cases, the first thing she said to me is, and I'm going to ask prosecutor to go ahead and accuse that PI case so that we can get all 3 together and in one fell swoop say, now everything's resolved, as opposed to we'll resolve this one, and you think, great, and just before you're ready to head out, you get grabbed by the ankle for your 660, your 6th lap, because you got that PI case. So give Ms. Rios a little time to get that discovery and to work with the prosecutor to see if the other case can be accused, and we'll bring you back here.
Months, we speaking of months?
No, we're talking about weeks. Okay?
Yes, sir.
See you soon.
Thank you.
Mr. Hines, tell me what update you've got on Miss Scott. I want to have her and her beautiful little kid not stuck in this courtroom much longer.
Yes, Your Honor, we appreciate that. I've spoken with Ms. Smith, and I believe she's going to make a recommendation to her office's diversion program. We know that, again, Ms. Scott has to be accepted into that, so we also talked about an alternate resolution, and we're both confident, I believe, that we'll have an answer for this case by the end of this month.
Okay.
As I, outlined, I have a scheduling conflict at the middle of April, but I also know Your Honor has a court date that I will be at April 2nd, so that's my personal.
What's the April 2nd date?
It's a final plea date.
Oh, for this case?
No, Your Honor, I'm sorry, just court in general.
Oh, okay, got it. And so your goal is to have lined something up, whether it is the district attorney's pretrial diversion program or some alternate that you and Ms. Smith agreed to, a series of conditions that would be diversionable.
Yes, Your Honor, and as always, I'll keep Ms. Nelson apprised of the progress.
Okay, I will backstop all of it with the April 23rd trial calendar. I hear you that you may be stuck in DeKalb, and so you wouldn't need to be here, but that's far enough out. April 2 is well before then, and we ought to be able to hear something from either the district attorney's diversion program or what you and Ms. Smith come up with, that maybe April 2 will be our magic day.
Yes, Your Honor, and also just for the record, I believe that if it is April 23rd, I can appear by Zoom because I'm sure the jury will just be deliberating.
Okay, sounds good. All right, Ms. Scott, you have any questions? Ms. Smith, anything else?
No, Your Honor.
All right, thanks. You guys are good to go.
All right, thank you, Your Honor. Good to see you.
Same.
Yes.
Avery.
Okay, then can we do Dodds? Because we've had Ms. Singleton stuck here. Or we can do Avery first. You said Avery. Ms. Rios getting a little pushy. Her one case, and it has to go first. Now I see how it works. You didn't offer to take Mr. Conley, huh?
You wanna do a drug program instead then?
If they don't go for this, their time, so.
Probably not gonna go to. So do you want a drug program
Are we,
He would like us to reset because he wants me to see if he can do a drug program now.
okay. Mr. Avery, you have a couple cases with some probation left in both of them. You've got 4 years plus some change in one and 2 years and a little bit in the other, but 4 is more than enough for drug court to work if you're accepted into drug court. I just needed to make sure there was enough time remaining on your cases. You were charged, one of the cases is a drug case. I have both here. They're both drug cases. And the allegation is more drugs and then maybe some family violence battery. But none of those suggest to me that drug court wouldn't work out. Have you received drug treatment before?
No, but I know I need it though.
Okay. The things I just mentioned suggest you might do well with drug court. So what we'll do, I guess, you'll do the outreach, Ms. Rios. You know how to contact the intake team.
Yes, I'll do the application today.
Okay. So Mr. Avery, someone from the accountability courts will want to meet with you. Be open and candid with them. It's a private conversation, but they're going to want to assess your need for drug treatment and the risks you face if you don't get drug treatment. So don't minimize things, don't exaggerate things, but say, look, I'm this age, I've been using these substances for this long, and if it makes sense, then, and they accept you into drug court, that'll likely be what then Ms. Rios advocates for as the way we handle this revocation, would be to revoke you into drug court, where drug court becomes a condition of your probation. And we see that all the time. And it often works out for people who are ready to get serious about recovery. And if that's you, then drug court could be great. Full disclosure, there are 2 drug court judges and I'm one of them. So you may end up working with me. That's just a coincidence. It's not because your revocation is here. They just alternate, one to this judge, one to that judge, on and so on. So it may be that we work together if you are admitted into the drug court program. In the meantime, you got to stay put so that the intake team can meet with you. And as soon as we get that answer, Ms. Rios can let me know and we can get you back in here, okay?
All right.
Any questions about that?
Is it like, just asking, is it like, will I be able to work too?
You will. Initially, it's a little hard to do it because it's 6 phases. The first phase, you are in the drug court building during work hours much of the time. And so if you work, it'd need to be weekends or a night shift, but you can't sleep through drug court. Once you get to phase 2, all the way through phase 6 is more meet in the late afternoon or evening. And in fact, when you get to phase 2, we expect you to have a job unless you have a disability. So you're going to have to work when you get to phase 2. You may be someone who wants to be working right away because you need the money, because idle hands are a problem. And we encourage that as long as the work doesn't interfere with drug court. And as I mentioned, phase 1, you need to be at Hope Hall. That's where drug court meets in the middle of the day, a bunch of days during the week. So you need to find weekend work or evening work for that very first phase. Is that a problem?
It probably would be.
Okay, well, that's something to talk about with the intake team. Because if that won't work, if you're someone who, I'm making it up, but if you're an electrician and you got to be at work from 8 until 4, Monday through Friday, you can't during the first part of drug court. But then you're not treating what ails you, and you may go back to work, and then I guess we'll see you again in a different format. So you may need to make a few financial sacrifices. Do you have a place to stay, or would you need supportive housing?
I would want supportive housing.
Okay, so if we are helping with supportive housing for the first 90-ish days, tell me what the urgency is to, like, I got to get right back to work 9 to 5 every day.
Well, to be honest with you, my drug problem is more important than getting a job from 9 to 5 right now.
Okay. That says drug court then is important, and we ought to see if we can make it work out. And like I said, you may be able to find a little bit of a legal side hustle where you're working in the evenings or on the weekends for that first few weeks. And then once you phase up, you get to phase 2. What is it that you prefer to do for a living?
I was working with Pine Lake City, like park and rec.
Okay.
But that's in the daytime. That would interfere with drug court.
But there's no reason you couldn't try to go back there after you finish phase 1. If they like the work you did, you'll be coming back and you're going to be extra sober. So they should welcome you back. But we also have some job readiness programs and job networks you can plug into. So it may be you find something else to do.
That'll be fine.
All right, but talk with intake. No one's forcing this on you. It's a great idea if it fits your needs. So we'll see what happens.
All right.
All right, Ms. Rios, anything else?
No, Your Honor, thank you.
All right, Ms. Smith?
Nothing, Your Honor.
You good? All right. Dodds? Hey, Mr. Dodds, if you come on up to the podium, stand in front of the screen, please.
Thank you.
All right, let's get on the record in your case, Mr. Dodds. It's 26 SC 000188.
Hold on, Jeff.
Sure.
Okay, sorry.
All right.
Thank you.
You bet. Mr. Dodds, I'm Judge McBurney. It's nice to meet you. Your case has been assigned to me. And today you're working with Ms. Wood. Ms. Wood is a close colleague of Ms. Gordon. Ms. Gordon's going to be your lawyer going forward, and you may have met with her before. She's got a conflict today, but we didn't want to delay today's hearing. So Ms. Wood is standing in for Ms. Gordon, and we're going to do two things. I'm going to ask Ms. Wood if you're waiving arraignment or if I need to read all the charges, and then we're going to talk about bond. Ms. Wood's going to tell me why you should get a bond and what that bond should look like. Then I'm going to hear from the prosecutor, Ms. Smith, as to whether she agrees about bond or disagrees. I'll probably hear from Ms. Singleton as well, who you just nodded to. She may have some thoughts about bond, and her thoughts are also important because she would be providing the supervision in connection with any bond if you made that bond. And I'll let you know what I'm going to do, okay?
Yes.
Great. First, Ms. Wood, is Mr. Dodd's waiving arraignment?
We will waive formal arraignment today, Judge, and I will get a waiver filed for him.
All right. Then let's talk about bond for Mr. Dodds.
Yes, Judge. So, first off, I think he's in no bond status right now. I didn't double check that because I couldn't see it on the jail odyssey, but I believe it's no bond.
He is. There was bond was denied on the 25th of November by Judge Ashley.
Okay, thank you. So he's in no bond status. We are asking the court to consider setting a $10,000 bond to go through the sheriff's 10% program for this case. Your Honor, he is 16 years old currently. He's been in custody since November the 7th of last year, so right around, I think a little over 120 days at this point. He was 15 years old at the time of the allegations. Your Honor, for a little bit, I know we're not going to dive into the facts, but it was important for Ms. Gordon that I get some of these facts out there for the court to consider. So on the day in question, Mr. Dodds was meeting up with an acquaintance of his, who is the alleged victim in this case, to do a clothing swap. Mr. Dodds told the complaining witness they were not actually going to end up doing the trade because Mr. Dodds' pair of shoes were worth more than the shoes that the alleged victim brought, and the trade was called off. They went their separate ways. Everything was fine. Later on that day, the alleged victim started blowing up Mr. Dodds' phone. Mr. Dodds finally agreed to do the shoe trade, but he was going to bring a less valuable pair of shoes to trade with the alleged victim. Once Mr. Dodds arrived, the alleged victim had his shoes out, but then the alleged victim took Mr. Dodds' bag, and that's where the shoes were, and handed it to another person named Larry. And Larry, at this point, tried to take the bag and make a run for it. There was a tussle over the bag, which had some shoes inside of it. Mr. Dodds heard gunfire. He had seen previously that the alleged victim had a gun in his waistband. Like I said, shots were fired, and Larry was hit, I believe, in the leg.
Larry is not the person with whom Mr. Dodds was going to have the shoe exchange. He's the bag grabber. After the shoe exchanger grabbed the bag, he gave it to Larry. Got it. And Larry gets shot.
That is my understanding. I believe he was, yes, accidentally hit in the leg. After all of this went down, everyone scattered, and Mr. Dodds went back and got his brother. They returned to the scene to retrieve his bag. And so he did take the bag, and I believe the shoes were in it, and another pair of shoes were at the scene as well. My understanding is a search warrant was conducted of Mr. Dodds' home. I don't believe a gun. No, police did not find a gun. So I know at the preliminary hearing, there was some testimony about an Instagram video that was at play. But again, we just wanted to get those facts out there for the court to consider. In terms of community ties, his mother and some other family members are here. Ms. Dodds, I've spoken with her out in the hallway, Your Honor. He would be living with Ms. Dodds. His grandmother also lives there. He also has 2 adult siblings.
This is on Triumph Circle? Is that the address?
Yes.
Okay.
He's a lifelong Atlanta resident, Judge, born and raised. All of his community ties are here. Before getting arrested, he was enrolled. He was a 10th grader at the City School of Atlanta. I did share some letters of support from the principal as well as the dean of students. I believe you may have received those today. They are vouching for him, said he does well at school, has wonderful relationships with all of his staff. We don't believe he's a risk to commit further felonies. I believe he does have one misdemeanor case in Clayton. I'm not sure. I hope Ms. Singleton may know if that one's still pending. I'm not sure what the outcome is of that one. He's also not a risk to flee. Of course, we are good with all the standard SB 440 bond conditions. And like I said, mom is very involved, judge, eager to answer any questions the judge may have, the court may have. He's not a risk to intimidate witnesses or the victim. He has no reason to have any contact at all with any of the people that are involved in this case. And he's not a danger to the community. No issue with house arrest, ankle monitor, all of that, because he understands, Ms. Gordon has explained to him in depth that if he messes up, Ms. Singleton will file a warrant and he will be put back into custody. And lastly, he shared with me this morning that he is on the A and B honor roll, so we're very proud of that.
In custody or at City School Atlanta?
In custody.
All right. Mr. Dodds, City School Atlanta, is that an in-person or a virtual school?
Virtual.
It's virtual? So you were
No,
in person?
Yeah, in person.
Like you would go to a building and go to classes and had classmates and your teacher's right there. It's not on a screen.
Yes, sir.
Got it. And how, if you were 15, were you a freshman or a sophomore at?
Freshman.
Freshman. So that was your first year there?
Yes.
Where'd you go to middle school?
I went to middle school there too.
Oh, at City School Atlanta.
Yes, sir.
Okay. Got it. Okay. Thank you. All right. Anything else, Ms. Wood?
I don't believe so, Judge, not at this time.
All right. Ms. Singleton, few questions and anything you want to share. Can you provide the juvenile history for Mr. Dodds?
Yes, Your Honor. He has one prior case out of Clayton County for obstruction. It's from January the 17th of 2025. There's no movement on that case, so I wouldn't expect anything else to be going to happen.
Okay, so it wasn't adjudicated or whatever the verb is. It was presented and it's stalled out. Okay, and it's obstruction.
Yes, sir.
Got it. Okay. If Mr. Dodds were given bond and released on bond, would he be able to go back to City School Atlanta, or would he have to go through a program of APS, or that's really up to City School Atlanta? It's a private school and they make that decision.
Your Honor, my understanding of it is that his mom has stayed in close contact with the school, and so he is able to go back. I believe the name of it is City of Refuge. But it's the old Bright Futures Academy, so the City of Refuge is the school. And so they are welcoming him back from
Okay.
without a problem. He has a counselor that was going to try to appear today. I believe there was a larger group of people in his prior hearing, but he is able to go there without a problem.
Okay. Is that Ms. Reddick, the counselor?
Yes.
Okay. All right. So assuming, we'll call it City of Refuge, but the school, if they took Mr. Dodds back, you would still supervise him. It's just he wouldn't be in an alternative school or at an APS school. He's just at a school where he is, I don't know if you'd still be a freshman, but he'd be whatever he is, and then you'd be plugged in the way you normally plug in.
Yes, Your Honor.
Okay. All right. Thank you.
And I did want to clarify the address that he's supposed to live at. Is it the Triumph or the Washington Street? Washington Street.
Okay.
It was 1019 Washington Street, apartment 5. Atlanta 30315.
Judge, I'll get an address change in as well.
30315?
Yes,
Okay. What's at the Triumph Circle? Whose place is that?
that's where he previously was residing. That's where the incident location. So they had to.
Okay. Got it.
His sister actually lived lives at that address.
At the Triumph address?
No, at the Washington Street.
1019 Washington Street. Okay. Got it. Okay. Great. Ms. Smith, your thoughts about bond for Mr. Dodds?
Yes, Your Honor, in this case, the state will be asking that the defendant stays in the no bond status. The biggest concern for the state is that the state believes that the defendant may be a danger to the community based on the facts of the case. I know that the defense gave a version of what was supposed to happen, and although we're not here to determine his guilt or innocence, looking at the indictment we have in front of us with aggravated assault, armed robbery, someone getting shot, the state does believe that these type of offenses rise to a level of concern. And based on what happened, the state does believe that the defendant may be a danger to the community. Furthermore, we do understand that the defendant does not have a criminal history of FCAs. However, the charges we have in front of us, they do run at a minimum of 10 years imprisonment, day for day, no parole. And we do believe that there is a likelihood that there may be a risk of not coming to court, which will avoid prosecution based on just the minimum of what those charges could run. So based on the state's belief that the defendant is a danger to the community and that there may be a risk of him being a flight risk, we would ask for the defendant to stay in the no bond status. I think that one of the victims may be here in the courtroom, but I'm not too sure. If so, if they would like to speak.
Sure.
That's great also. If the court is inclined to give a bond in this case, we leave it to the court's discretion. However, the state does believe that this case should stay in a no bond status.
Okay. Do you want to check to see if there's anyone who wants to be heard?
Yes. I guess not.
Okay. Got it. Mr. Dodds, tell me what classes you were in at the high school.
I was in math, reading, language arts, and I was playing basketball.
Okay. What was the hardest class you were in?
I say reading,
Why do you say that?
cause it was just tough,
Yeah.
yeah.
How many students are there?
It like in the whole building,
Or in your class? Like if you were in reading, how many other kids are there in the reading class?
it like 8,
Okay. And in the freshman class, about 8?
yeah,
Okay.
sure.
All right. Ms. Wood, tell me again who would be in the household at the Washington Street apartment?
I believe it's Miss Ivy Dodds and the grandmother.
Ms. Ivy Dodds is mom?
Yes, she's right here.
Okay. And then grandma?
Yes, and then, I think there's another,
And the person who raised her hand is sister? Okay.
and then I think there's, another adult sister and brother that live independently, like Miss Singleton was referencing, so.
Okay. Got it. And Ms. Dodds, do you work? What do you do?
I'm a custodian at Georgia State. I've been there 7 years.
Okay. And your daughter next to you, is she school aged or is she done with school?
She's not in school.
She is in school?
She done.
Done. And,
She's 22.
okay, and does she work outside the home?
She worked as well.
What does she do?
She's working at Georgia Tech as well, and Nine.
It's a Georgia Tech family. Okay. All right. Okay. Mr. Dodds, is there anything you want to add?
Oh, sir.
Okay. Well, Mr. Dodds, I am going to set a bond for a couple reasons. But before I share with you those reasons, you need to understand that you're in a real serious situation. My guess is you figured that out because you've been sitting in a YDC for a long time. And now is not the time to screw around. So if your family is able to post this bond while you are out on bond, you need to lead a very boring life. No clothing exchanges. If there were guys you rolled with who are kind of flashy or tend to get the attention of police, don't. Just be boring for a while. Play basketball, do your hard reading, whatever it is. If you get sideways with the police, if Miss Singleton has trouble finding you or is getting reports from school, hey, Dodds skipped school or he got in a fight at school, we're done with the experiment of seeing how are you doing on bond. As I know I can find you if you're at the YDC. And I know you're not going to do another thing like this, whatever it was that happened, if you're at the YDC. but the YDC isn't the safest place in the world, and you're not getting the same education, and you're not there for your mom and your family. So we're going to try out bond. It's going to have restrictions, but you need to know that for a 16-year-old, life is going to be kind of boring while you're out on bond until you resolve this case. All right?
Yes, sir.
Is that clear?
Yes, sir.
Okay. Because if you screw around while you're on bond, the real easy fix is to say, we're done with bond, and we'll just get you back to the YDC. You'll continue to get A's and B's, but it's just not the same world as being at school and being able to go home at the end of the day. You miss Thanksgiving, you miss Christmas, you turn 16 away from your family, and that's not how it should work. But you got mixed up in something where, fortunately, no one died. But the moment a gun goes off, it could end with, we're not talking about a few years or this or that, it's life. So you just need to keep your head down until this gets sorted out. So I will set a bond. I got to spread it out across all these charges. So I'm going to set a bond of $15,000. It'll be through the sheriff's 10% program, which means the money that people put up, they'll be able to get back when the case is resolved. So they're making an investment in you, but they'll get that back when the case is resolved. A special condition of your bond is that you will need to have no contact with Larry Newell. That's the guy who got shot, as well as, I guess, Derek Wilson was the person you were going to be exchanging shoes with.
Yes, sir.
So you got to leave those guys alone. Sounds like if they are down near Triumph Circle, then they don't go to your school, do they? Good.
Sir.
So no contact with them. And then there are going to be a set of standard conditions that Ms. Singleton is going to state for the record about an ankle monitor and a curfew, and you can be away from home for school and doctor and things like that. But otherwise, you're at home, staying out of trouble, doing your homework, and helping your mom take care of the household. Okay? Ms. Singleton?
Yes, Your Honor. The defendant would receive a 24-hour curfew except for school, medical, legal appointments, and anything else that is able to be approved by myself.
And that would include, making this up, but if you made the basketball team, that would be really an extension of school. That if there's a game at 5 p.m., even though school lets out at 3, curfew would include, hey, you can play in the basketball game.
Yes, Your Honor, all extracurricular activities.
Okay.
Included and encouraged.
Yes.
That he will be fitted with an ankle monitor that will be paid for by the Department of Juvenile Justice, and receive wraparound services paid for by the Department of Juvenile Justice, which is the in-home counseling. He just turned 16. However, if the defendant's case is still open at the time that he turns 17, that he would convert over to the county-funded ankle monitoring. Your Honor, that he would have no social media, no weapons, supervision by myself, and release by myself. Your Honor, and if we could add anger management on this case.
Sure. So you will need to be enrolled in a class about anger management. Ms. Singleton will help line that up, whether it's at the At Promise Center or through school or who knows what, but that'll be part of your bond conditions. And I'll tell you, Mr. Dodds, the one that Ms. Singleton said that's probably going to be the hardest is that no social media. That means you aren't messing with TikTok. I have a 15-year-old, and I think his head would explode if I said you can't be on social media, because he is always scroll. That's what he does. You don't get to do that, and you need to take that seriously. You may think like, all right, Singleton's not looking now. But if it comes to light that you're on social media, that's where we might need to lock things down and say, well, now you can't do extracurriculars. Or if it's enough, we say, you got to go back to the YDC. And it's not because we're taking some old person view that social media is bad for you. It's because that's where you make connections that right now you shouldn't be making. Where you're like, hey, I'm just scrolling, this guy's selling some sneakers and I like those. And then all of a sudden you find yourself in a situation like this again. So it's not a knock on social media. It's an effort to keep you from getting entangled and something that right now you don't get to be entangled with because you're facing these kinds of charges. Okay? Any questions about any of the things we've been talking about?
No, sir.
Ms. Dodds, do you have any questions? I'll make sure you understand he's going to be up in your business a whole lot because his curfew, he is home all the time. His sister's going to want to get out of that apartment, but that's a small price to pay to have him around for Christmas and his birthday and that kind of stuff. So I just need to make sure you're signing on for, yep, it's a curfew. I want him out of my house Saturday morning. He doesn't get to.
Thank you so much, Judge.
Okay, well, you can thank me by making sure your son does well under the conditions of this bond, because Ms. Singleton is very dialed in and she does not hesitate to say, Judge, guess what? Someone didn't come home last night. And all right, let's try 30 days at the YDC and see if that fixes things. And so we'll see. I hope we don't run into those issues. I know Ms. Gordon is going to work closely with Ms. Smith to try to get to the bottom of this. There are two sides to every story. Something bad happened because the gun went off, and we need to figure out how to sort all this out. I'll get that bond paperwork signed today, and we'll go from there. All right?
Thank you, Judge.
You're welcome.
Mr. Johnson.
Mr. Fortis, did your client get on? Let's look. Yes.
Yeah, I do.
Whoops, that's the wrong one. There he is. All right, Ms. Smith, are you able to pivot to our afternoon calendar again?
I am, Your Honor.
Appreciate your flexibility today. Let's get on the record. Ms. Rivers in position 2 from our final plea calendar. This is 25 SC 004117, State versus McWell. Mr. McWell is appearing virtually. His lawyer, Mr. Fortis, is front and center here in court. And Ms. Smith, the prosecutor, is here. Mr. Fortis, it's the final plea day. I always start by asking about discovery. Any discovery concerns, or you feel like from your review of what you got, you've got everything that's out there?
I feel like we have everything.
Good. All right. Ms. Smith, what is the state's offer if Mr. McWell wanted to resolve things today?
Yes, Your Honor, the state's offer is 10 years to serve 2 with the balance probated.
All right, and that would resolve all the charges.
Yes, Your Honor.
Okay. Mr. McWell, were you able to hear what Ms. Smith said?
Can she repeat it, please?
I'll repeat for her. I'm closer to a microphone, or at least one that's on. So the state's, if you were to enter a plea today, and you do not have to do that, I'm gonna talk to you more about it in a second, but if you were to say, you know what, I want to resolve this today, I don't want to go to trial, they got the goods on me with the evidence in this case, Ms. Smith would recommend a sentence of 2 years in custody, followed by 8 years on probation. So that's 10 served 2, balance probated. I don't know if you spent some time in jail on these charges, but if you did, you'd get credit for that. But the state would be recommending 2 to serve, followed by 8 on probation. Mr. Fortis is not bound by that recommendation. He could advocate for a lower sentence. If I sentenced you today, if you pled today, to anything more than what Mr. Fortis asked for, you would be able to withdraw your plea. That's the special superpower you have today, is that you could say, you know what, Judge, no thanks. I don't like that sentence because it's more than what my lawyer asked for. Tomorrow, or any day after tomorrow, you could still enter a plea. What will change is that you will not be able to withdraw that plea if you're unhappy with the sentence that you get. So today is the last day to have that safety release valve of like, hey, I'm gonna plead, but if it doesn't go well, doesn't go the way my lawyer's asking for, I can get out of it. After today, you can still go to trial. You always have the right to trial. But if you want to resolve the case by way of a plea, you just don't have the ability to back out if you don't get the sentence that your lawyer advocates for. Do you understand that?
Yes, sir.
Okay. Are you interested in pursuing the state's offer today?
Well, Judge, may I address that real quick?
You sure can.
So ADA Smith is relatively new to the case. There had been previous discussions regarding resolving this. I've got to go back and review my notes regarding other offers that were made, and I need to get that to Ms. Smith. I recently got that offer from Ms. Smith and have not even yet been able to meet with my client to discuss that offer. And also, I held off filing an immunity motion based on prior discussions with previous ADAs. So the case has changed, I wouldn't say dramatically, but sufficient enough to where I'm going to need a little bit more time, number one, to discuss the offer with my client because it was just recently received. Number two, I believe it was ADA Davis who was in here before that I had some discussions with, but I need to make sure that I don't want to misspeak, and I want to make sure that those were the discussions I had with her. Then I'll relate back to Ms. Smith regarding those discussions. So I guess I would ask the court a couple different things. I'm not sure what the court would be inclined to do, but number one is I do need a little bit more time to vet that out. I do need time to discuss what's going on with my client regarding the offer, regarding non-negotiated plea and things of that nature. So I would ask, I guess, for another final plea or whatever the court may be inclined to do. I'm not in the position right now, just based on getting, I guess you would say, an amended offer or another offer from ADA Smith.
Okay. So I think we can accommodate it. I'll tell you how in a moment. And I know you know this, but I want Mr. McWell to hear this. If Ms. Davis talked to you about numbers, but didn't extend a formal offer or extended an offer that says is good as long as I have the case, of course, that doesn't bind Ms. Smith in any way or the DA's office. But if it was a formal offer and she said, I'm making it up, 5-1, and she didn't say it has an expiration date, then certainly you and Ms. Smith need to talk about it. And Ms. Smith will need to talk with Ms. Davis.
I agree.
Ms. Smith isn't trying to rock any boats. My guess is there wasn't something in the file explicit from Ms. Davis, or even, this case is old and it may have been a different prosecutor who had the case. But I haven't known Ms. Smith to disregard offers that would have bound her office. So I think it would be good for you to talk with her. She can engage with Ms. Davis and see where you get. But Mr. McWell, you need to understand that if all that happened, and I'm not saying this is how it played out, was that Ms. Davis, the previous prosecutor, and Mr. Fortas had informal discussions, and Mr. Fortas said, hey, what do you think about something like this? And Ms. Davis said, I could see that maybe. Mr. Fortas may have been optimistic, but that didn't obligate the prosecution to go with that. And so he may want to get optimistic with Ms. Smith as well, and he's going to have time to do that. But it may well be that Ms. Smith is actually free to come up with the recommendation that she thinks is appropriate, which right now is the 10 to serve 2. But we'll revisit that as we need to. The way I'm going to accommodate your request, Mr. Fortas, is to not set another final plea date, because that's what this is. The trial date is not until April 23rd. And that's actually calling the calendar. That's not even the trial. But I will preserve Mr. McWell's final plea rights. So that gives you a month and a half to, one, get with your client, two, get with Ms. Smith, and maybe you, Ms. Smith, and Ms. Davis are needing to talk about it. But that's plenty of time. And as you know, if you sort something out before that date of the 23rd, let's get together and knock the case out. If you don't, that's the day we call the calendar. That will be the day that the final plea rights expire. So between now and then, if you bring Mr. McWell in, even if it's non-negotiated, and maybe the state sticks with the 2 to serve and you're advocating for probation, Mr. McWell will be able to withdraw his plea. The last day he could do that would be the day we call the calendar, which is April 23rd. After that date, again, he's free to plead, but then he's in, like, pleading in the middle of trial. That's sort of the effect we've got.
I understand.
So I think that gives you the time that you're asking for, but we don't have to take this case off schedule, which is to get it on the April trial calendar.
I think we're fine.
Good. Mr. McWell, did you follow all the things your lawyer and I just discussed?
Yes, sir.
Any questions about that?
No, sir.
Mr. Fortas, you dropped the I word on us. And you know the law. The reality is you could file an immunity motion the day before we pick a jury, and we'd need to work through that. Because if I said, no, I don't want to do it, then you're ineffective and we'd have to do the trial all over anyway. My request to you in exchange for extending the final plea rights is to engage with Ms. Smith sooner so that you determine if the state is not budging from the 2 years to serve. And for you, that's the trigger to drop the immunity motion. You drop it so that we can get that scheduled. Because that's the trial.
I understand, Judge. And let me say this. I've had very good conversations with Ms. Smith, and we've discussed this, and we'll continue to discuss this. And I should have something either done or filed within a week.
Okay.
So,
and to be clear, I'm not discouraging the immunity motion. Just
No, I
the
understand.
sooner you reach the crossroads of, I gotta need to protect my client's interests. I'm not going to get a plea currently that is reasonable. We got to do the immunity motion. I just need to get that so that we can get that calendared. We likely wouldn't do it before the trial calendar, but we wouldn't have to miss too many trial calendars before we could schedule the immunity hearing. And as you know, that's probably the trial anyway. Once that's over, people are like, oh, either the case is tossed or now everyone knows it's not such a great self-defense.
Understood.
So we'll see how that goes. Ms. Smith, anything else from the state in the McWell case?
Nothing further. Thank
All right, thank you. You're good to go, Mr. McWell.
I'll be in contact with you, Mr. McWell.
Okay, y'all, thank y'all so much.
Bye-bye.
And thank you, Judge. Thanks for accommodating me a little early.
You bet.
It's good to see you as always.
Same. Did Mr. Johnson make it yet? Or we're hoping he'll be here this afternoon? Is that how we left it? I'll ask. Okay. I think all we have left, oh, no, we have a couple others.
16 is liberated.
Yeah, I know, well, because he drives everywhere, but I have to be in the seat right next to him, chewing on my nails.
Mr. Johnson's coming at 1:30, Judge.
Okay, great. So Mr. Johnson will be here. I think all we have left for this morning is Mr. Hill.
Yes.
And your friend, Mr. Conley. Okay, you, whatever you want to do, you're both yours. You call them how you want to do. Other than that option. Nice try.
Dealer's choice.
You all right, Mr. Conley?
Yeah, I'm all right.
Okay. All right, if you'll slide towards the monitor a little bit, Ms. Wood is going to come stand next to you. And I'm going to add one other screen for Ms. Rivers. And we're going to get on the record in your case, which is position 12 on our plea and arraignment calendar, 21 SC 178070. Mr. Conley is here in court with Ms. Wood, and we have Ms. Smith for the state. And Mr. Conley, we have also in court Ms. Simpson from probation, and she may have a little bit to add about, your situation. Mr. Conley, you have 2 years and 25 days remaining on your probation in this case. It was an aggravated assault case, and the allegation in the petition for this revocation that I signed in December is that you were arrested in August of last year for being a felon in possession of a firearm, and you either had an obscured or missing license plate. So that's one arrest. And then you were arrested. That sounds like the same day. That's the same thing, that you had a firearm. And then you hadn't paid some of your fees. I will tell you that you need to pay your fees, but that's not the serious aspect. The serious aspect that we're working through are the allegations involving that late August arrest with a gun. We are not dealing with your unindicted cases today. You understand that?
Yes.
Yes. This may impact what happens with them. If you get revoked for some time, it may well be that a prosecutor says, we don't need to pursue those charges, or we'll bring those charges and just run it concurrently. But formally, there's no connection between this revocation and the unindicted cases. You understand that?
Okay.
I just want to make sure you knew that.
So meaning that if I take my whatever plea that I get today, I go to prison and they'll call me back up from prison for my other cases.
Yes, but they may not even bring you from prison. I'm going to do a hypothetical that they go ahead and accuse you or indict you for this gun situation. We know where you are, and so it may well be that Mr. Toller or a public defender reaches out to you. You say you're in Valdosta State Prison. Hey, Mr. Conley, those charges were brought. The state's offering, again, I'm making this up, 1 year concurrent running at the same time. You may say, great, let's take care of it. I don't want to come back to Fulton. Get me on Zoom and I'll take my plea from Valdosta. We typically do it more that way, so we don't drag you back up here so you can stay where you are. You may be in a program doing something you want to be doing, and so we connect with you virtually. That's more likely if they even do something with those charges.
Okay.
Does that make sense?
Yes, sir. One more thing. So am I eligible for TC?
Tell me what that is.
Transitional Center
Um,
Program?
Yeah, I don't know why you would not be. That would be at the back end of your sentence. So if I were to revoke, and I don't know that I'm revoking anytime, we're not there yet, but you're asking good questions. Let's say I revoke 18 months. There's no reason I can think of why you would be ineligible for a TC. You wouldn't start out there necessarily. You might go, everyone goes to Jackson first, but they do the diagnostic, they look at the what the revocation is and say, well, you know what, he'd probably be paroled at X months anyway. And so then you go to a TC. So I don't think you are ineligible for one. A lot of that has to do with how you handle yourself while you're with them. And you express interest in it, as long as you're not making waves, then why not? You need to know I don't control it. The judge can't tell the Department of Corrections what to do. They're very clear about that.
So
I can recommend it, but they do their own thing.
So with probation, do they do 2-for-1s?
No, they're,
County time? Don't do 2-for-1?
you have lots of good questions, some of which are based on myth, this county time and not. All depends on what we end up doing here. So hold that question and let me hear from Ms. Wood, and then I'm gonna hear from Ms. Smith. I may hear from Ms. Simpson, and then we'll figure out which way we're going, okay? All right, so Ms. Wood, is Mr. Conley stipulating to the fact that he was arrested for these charges?
It is my understanding in this moment, Judge, that he is stipulating to the arrest and that we are handling this as a non-negotiated stipulation.
Okay, and what is your recommendation as to what ought to happen in Mr. Conley's situation?
Based on my conversation with him previously, I have a feeling he will interject if he changes what his recommendation is. I believe we are asking the court to revoke 6 months on this case. Judge, he has been in custody 80 days so far. He's 32 years old. He has 13 children to take care of. He sells t-shirts and washes cars to do that. And I believe that he is eager to put this violation behind him and move forward.
All right. Yeah, you've done 80 days to the door so far, since you got picked up on the probation warrant. 13 kids. How old is the oldest?
15.
And how young is the youngest?
Like 6 months now. I have 2 newborns.
Okay. How many moms in the mix?
13.
13. All right. When you say you sell t-shirts, do you do your own silk screening, or you have a supplier and then you sell them?
Actually, my fiance, she prints on the shirts and we sell them like that.
Got it. So she does the design work
The design work and I just.
and you sell them?
Yes, sir.
Okay. All right. Are they like concert t-shirts or are they like whatever she comes up with?
Whatever events or funeral arrangements.
Okay, so someone might reach out saying, we just lost so-and-so, could you do, we're gonna have 100 people at this funeral in memory of, and she'd do a shirt.
Yes, yes.
Okay,
Sir.
got it. All right, Ms. Smith.
Yes, Your Honor. In this case, the state is going to follow probation's recommendation of revoking 2 years based on on behalf of the state. We believe that the underlying charge here dealt with a gun or involved a gun, and this new offense also involves a gun. So, for the purposes of that and the technical, both the new arrest, the state will be asking to revoke 2 years in this case and to terminate the balance.
Mr. Conley, were you in prison when we took this plea or were you here in court?
What plea?
You were represented by Mr. Olaloye.
I was actually in front of you.
You were here in person?
Yes.
Okay.
My case, that is not my record, sir. That I know you see that it says I've been to prison before, but I never.
Oh, no. I don't actually have anything like that. I was trying to, Mr. Olaloye has had a couple cases with me, and I know one of them, his client was in Department of Corrections and we did the plea, but that's not you. And that's okay. I was just trying to remember anything about the case. So you were sentenced to 7 years to serve 2 years. And okay. All right. Ms. Simpson, is Mr. Conley on probation in any other case? Has he been on probation before? Are you able to tell that or do I need to?
Yes, he had. Prior to case 14 SC 12576, I'm sorry, which was a robbery charge as well as a firearm.
Okay. We do have pretrial on. Good morning, pretrial. We haven't had to call on you yet.
Good morning, Your Honor. I'm sorry.
That's all right. Ms. Stallworth, how are you?
I'm good. How are you?
I'm fine. How many cycles does Mr. Conley have?
Can you give me just 1 moment and I'll look for you? Hold on.
Sure. You need what?
Just 1 moment.
Oh, give you a moment. Yes, you can have a moment also.
Oh, yeah, that's the judge a minute.
And Ms. Smith, while that's been looked up, the recommendation is to revoke 2 years and I assume terminate after, I mean, it was the remaining balance is like 5 days or something. It's a month. Yeah.
We'll be
So,
able to terminate the balance.
okay.
Judge, do you have to Zoom up? Mr. Conley wanted to know if he had a family member on the Zoom, but he can't.
And there's a Wyteria Bailey.
Yes, that's my fiance.
Okay. Ms. Bailey is on.
Okay, thank you.
Sure. This is the t-shirt person?
Yes, sir.
Okay.
Your Honor, I'm showing 15 cycles total.
1-5?
Yes, sir.
Okay. And how many felony convictions?
1 moment. Hold on. I'm sorry.
While she's looking that up, you have 2 unindicted cases. One of them is this situation we're talking about now. What's the other charge?
Shoplifting.
Shoplifting? Okay.
Yes, sir. Excuse me, Your Honor.
Yes, sir.
So when I first signed up for probation, they told me if I did if I did like a year clean with no mess ups, they was gonna release me off of probation. So they did it on a body cam. I'm just trying to figure out why did I never got released off of probation?
He wasn't released, he was switched.
Unsupervised, yeah. So there are different levels. The first level of release that you get is that you shift from being supervised, where you have to check in with your officer, to unsupervised. And so there may not have been real clear language used, but let me just finish and then I'll hear from you. It would be uncommon, and frankly, a judge would have to sign an order to terminate the probation early.
So he told me he was gonna terminate the rest of my probation if I gave him a year clean. That was my first probation officer. The following month, they changed my probation officer to another officer.
Okay, well, they did not terminate. It may have gone to unsupervised, but it wasn't terminated. Again, that requires a judge to sign it because the sentence isn't from probation, it's from the judge. So they would have had to reach out to me saying, Judge, we would like to terminate probation. Mr. Conley's been doing great, gave us a year of no hassles, and let's do that. But that didn't happen. So I'm not saying the officer didn't tell you that, but either because they changed officers or that officer was being a little loose in his language and meant to say it can go to unsupervised, which Ms. Simpson says it did do, that they shifted to unsupervised, but that's still probation. And if you pick up new charges, whether you're being supervised or not, that's a violation of probation. Ms. Stallworth, any luck?
Yes, Your Honor. I'm sorry, my computer was freezing, so give me just a minute. I was trying to get somebody else to tell it to me. There's a 2013 conviction,
Okay,
for willful obstruction, a 2016 robbery, death by taking, a 2023 felony criminal damage to property, a 23 aggravated assault. Okay, and that's all that was listed for felony convictions.
got it. Thank you so much. Sorry about your computer.
I'm sorry.
It's all right. These things happen. All right. Ms. Wood, anything you want to add?
No, Your Honor.
Mr. Conley,
Yes, sir.
you're juggling a lot of kids, fiance, business, a lot of charges, 2 open cases that you need to sort out. You were on probation for a gun situation.
No FTAs.
I appreciate there were no FTAs. I'm not worried about that part. I'm worried about you and guns. I am going to revoke 18 months of your probation and terminate the case. So you will complete the revocation. You will not be on probation anymore for the 21 SC case. Between now and the end of the revocation, if Mr. Toller, he's handling both your unindicted cases?
I don't know, you can ask my fiance. Yeah, the shoplifting, he's supposed to be picking up the shop. He's supposed to pick up all 3 of the cases when she said she didn't want to get on.
Okay, but I don't want to retail that ground.
Yeah.
I'm only asking because whoever the lawyer is, whether it's Ms. Wood or Mr. Toller, ought to reach out to the DA's office to say, hey, there was just this revocation. Is there a way we can roll these 2 new cases into that revocation so that Mr. Conley doesn't have to keep coming back to court for what are now interconnected things? Because I revoked you because of the new cases. And so they ought to all wrap up together. They're just not indicted yet. So someone on your behalf, Mr. Toller, Ms. Wood, ought to nudge the DA's office a little bit to see if they can make that happen. That'll be most efficient for you if they can do that. Ms. Wood, anything else on behalf of Mr. Conley?
No, Your Honor, thank you.
Thank you.
Yeah.
Ms. Smith?
I'm sorry, I don't mean to interrupt. My computer is working now. The FTAs, there was one in 2013 and 2015, both out of
Okay.
13.
Thank you. So you did have FTAs, but that's not why we're doing what we're doing. Ms. Simpson, I don't need to give Mr. Conley reporting instructions because he'll be done with probation. All right. All right. Good luck, Mr. Conley.
Thank you, Judge.
I have a security number. Can I have a copy of everything in writing, please?
When you say everything, tell me what you mean.
My sentence.
Yes, we'll make sure, so the revocation order will come from Ms. Simpson to me. I'll sign it, it'll go into the docket, and either Mr. Toller, if you've retained him he can pull that out of the docket and get it to you, or if you're gonna go with the public defender, it'll be available, so that can get sent to you.
So 18 months.
That's exactly what I said, you heard it.
So that was it. Like I should have just went to trial. I should have just went to trial for 18 months. That's crazy, cuz. I didn't know who this off.
Do you need to take him downstairs or are we good? We're good. Lattimore will take care of him. Mr. Hill is the only other situation. Have you and Ms. Smith talked about his?
Yes, we're hopeful to have like an actual resolution for this case.
Yes, entering auto.
Judge, I'm trying.
All right.
Just not there yet.
Good. It's still morning. Good morning, Mr. Hill.
Yes, sir. Good morning, Mr. McBurney.
You are here because you missed court one day and we need to figure out how to move your case forward and what to do about the missed court date. So you had arraignment in April of last year here after your case was transferred from non-complex. You'd been to court a few times in non-complex. They transferred it here. Why?
Judge.
You're not a repeat offender.
Correct. I dispute the basis for the transfer.
Too.
But no one asked me.
Yeah, and it slid by us. Oh, because it's supposedly complicated because a CODIS hit. Okay, you must have left blood somewhere, allegedly. Either way, case is here, and you missed court. That bench warrant caught up with you. Looks like you've been in custody now for a couple weeks, and we're going to talk about whether to set aside the bench warrant or to keep you where you are until we can resolve your case. I might hear from Ms. Wood.
Thank you, Judge. So like I said, we are working with Ms. Smith. I hope to have a resolution real soon. It's just not going to be today. So I will do a waiver of arraignment. It is a 2021 incident date.
You don't need to waive arraignment. That happened already. It happened in November of 24 in non-complex. So we don't need to re-waive.
Perfect.
But we'll do a scheduling order.
All right, and I'll do a substitution of counsel then.
Yeah.
He's been in custody on the bench warrant, I think 26 days. I'm just asking the court to set it aside and reinstate the bond. I do have an address. I'm gonna get an address updated. He lives here locally. He's 29 years old, Judge. He was working for Amazon as a delivery driver prior to this arrest. He does have his GED. He tells me he just did not get notice. I feel like I get a lot of these, when these transfers happen, I don't know what the disconnect is, but I feel like I get a lot of bench warrants from a non-complex transfer. So
yeah,
I'm not sure what happened. I will get a change of address in the system. And like I said, we're close to having a resolution on this one.
Mr. Hill, one address that's in the system is Curry Drive in Forest Park.
Yes, sir. That's my aunt address.
That's not where you live?
No.
Is that where mail can get to you?
Yes, sir. I was staying like right around the corner from her on Springwood Drive, and that's how I received my mail, but I had got evicted around that time. And I was like going through housing, so that's why I was getting mail. But when I started back working at JCPenney, I couldn't get to no mail, so I don't know if it came or, you know.
Okay. Let me look to see where the notice was sent.
One in Atlanta. What's the
Yes, that's Morrow, Georgia.
Oh, it's in Morrow?
Yeah, that's where I stay at now.
What's the zip code?
30263.
Okay. And then that's the apartment number?
Yes.
Okay.
So the court date that you missed, we did send notice out to the Curry Drive address in April of last year. So I guess your aunt would have received it, but you're saying you didn't live near her at that time because you'd been evicted from
the address like around the corner from her, yes, sir.
Okay. And if you get out now, where are you staying? I know I don't need the address, but is it an apartment? Is it your dad's house? What is the place?
It's apartment, yes, sir.
Whose apartment?
Me and my brother.
Okay, so your brother is paying for it?
Well, we, split on half of the rent.
Okay, but you've been in jail for a little while. He's paying for it right now?
Yes, sir.
Like it's still there?
Yes, sir.
Okay. Does your brother work?
Yes, sir.
What does he do?
He works now at a motel. Yeah.
Okay, so between the two of you, you're able to afford the rent for the apartment?
Yes, sir. If not that, my dad, like right now, since I've been locked up, my dad will help him because I had at one point in time before I had started working at JCPenney, before I started working at Amazon delivery, from my record, like I didn't have a job for like 6 months. Like, I was applying, but I didn't have a job for like.
When you say from your record, meaning you've been in trouble before?
Yes, sir.
Okay, got it.
So I didn't have a job for like 6 months. So around that time, when I started staying with my brother in March, when I got evicted, I think this was last year.
Okay.
I got evicted. I went to stay with my brother, but long story short, my dad helps pay the rent if I don't. So right now, yes, my dad. So
okay. So rent's being paid. Hopefully you'll get a job back soon. But your brother's working and you'd be living with your brother.
My job, Amazon delivery. I called them when I got locked up. They told me that I have my job when I go home. So
okay. Do you have a car or you drive one of their vans?
I drive one of their vans.
Okay.
Yes, sir.
One of those little electric ones?
Yes, sir. The river van. Yes, sir.
Wow. Okay. Ms. Smith, your thoughts about setting aside the bench warrant?
Yes, Sharon, in this case, the state doesn't have a problem with setting aside the bench warrant. We would consent to it. We're trying to wrap up this case as soon as possible, but we'll get an offer to Ms. Wood, but before then, we don't have a opposition to setting up the bench warrant. Sorry.
Is there anything complicated about I'm just looking at the indictment and the allegation is that Mr. Hill broke into kind of old Cadillac. And I guess maybe he left some blood behind and that's the CODIS ink. I mean, that's why non-complex kicked this to us.
That's my understanding too, because I don't see that.
It's not like it was 100 cars or he used some sophisticated laser to break in. It's just that there was a CODIS hit that connected him.
That's correct.
Okay. I mean, it just makes the case stronger, but okay. Transfer to us. All right. So I learned recently, Ms. Wood, that we need to check to make sure bonds haven't been surrendered. Because I usually just say, great, I reinstate the bond. But if the bond has been surrendered, I can't reinstate the bond. And so I've just reached out. I don't remember if you can tell sometimes you can see it in Odyssey because the bonding company will say, we surrendered. But often, I think often's the right word, something happens at the jail, just because that's where you go. They go wherever you go to the sheriff's office to surrender a bond, and it doesn't make it into Odyssey. And so I have just reached out to find out who I need to ask. I think there's some email address where I can ask, was the bond surrendered in Mr. Hill's case? And if it was, then we need to do a new bond.
Sure.
So Mr. Hill, I will set aside the bench warrant. I just need to figure out if your bond is still in place. You were given a $10,000 bond back in July of 23, which you posted, you got out. And as long as the bonding company is still on it, then all I need to do is lift the bench warrant. But if the bonding company has surrendered the bond saying, hey, the guy's in jail, you don't need us anymore, then I need to issue a new bond, which I will. But you'd have to post it before you could get out. Okay?
How long is that gonna take?
I should get an email back in the next hour, I would guess, that tells me how to figure out whether the bond has been surrendered. I will let Ms. Wood know. It's not a secret. I'll share it with her and the prosecutor saying it was not surrendered, and then I just lift the bench warrant. If it was surrendered, then I need to lift the bench warrant and enter a new bond order. Because otherwise you would be out with no bond and there's no mechanism to make you come back to court.
Yes, sir.
And we just, to both Ms. Wood and Ms. Smith's point, we just need to resolve this case. It's not a super serious charge. Frankly, if you left your blood in the Cadillac, you ought to want to work it out. So we'll see, but we'll figure that out. I'll have that answer today and I'll do the paperwork today. If all it is lifting the bench warrant, then you should be out tomorrow at the latest.
Yes, sir.
If you have to post a new bond, then you'll need to get the resources together to post the new bond.
Yeah, so with that, with posting a new bond, are you already gonna set that or I'm gonna need to come back to court?
I'm just gonna do the same bond as before. The only change is I'm gonna do it through the sheriff's 10% program so that whoever posts it gets the money back, whether it's your dad, your brother, you get your money back when you resolve your case. When you go through a bonding company, you give them the money, they're richer, you're poorer, and that's it. But with the sheriff's program, you put money in, it's held by the sheriff, and then when your case is resolved, you can get your money back.
So is that a cash bond or what is that?
Well, someone needs to give cash or a check to the sheriff's office. So yes, in that respect, but you just aren't going through a bonding company.
I was just trying to go home today, sir. That's all.
I understand, and that's an admirable goal. I wouldn't want to be where you are, but we got to sort this out, and Ms. Wood has taken you in the right direction with that, okay? So I'll get my answer, I'll let the lawyers know, and then Ms. Wood can let you know.
Yeah, because I'm in Cobb County now, man.
Yeah, there are worse places to be.
Yeah. All right, thank you.
You bet. I think it's lunch break. Is that right? I don't think there's anything else from this morning. I mean, there's Mr. Johnson, but he's going to be part of the afternoon calendar, which shrank by 2. Any pleas this afternoon?
I should have one. Just tell them Moses should be a plea.
Rios. Okay. Yeah, some of these charges don't look so pleable. All right. We've got cupcakes back in chambers if anyone wants to try some.
Want a diet?
They're small cupcakes. You could just take one small one.
That's the.
We actually also have, Judge Ellaby made them.
Oh,
So, we also have donuts. We don't normally have both, but the donuts were to celebrate. The cupcakes are a bribe, and they both arrived on the same day. No opposition.
Oh, congratulations.
Thank you.
When did that come out?
Friday at noon.
Oh, okay, that's why I missed it. No one's running against him.
Oh.
You should be more excited than me.
Oh, you know it's good.
I'm on a diet. I'm not going to celebrate anything because I can't have a cupcake. Bleh. So the rest of you suffer with me. All right, bonds. Let's see what it says. So I go to that tab, bonds.
You don't have Tayshaun Johnson, right? You don't have Tayshaun Johnson. On the final thing, you don't have this one done. Is that, is.
How long have you been on this diet?
Like 2 days. I'm bringing the chocolate this morning, and the first thing she says is, "I'm on a diet." But I ate so bad when we were in Atlanta. I took my son to Magic Kingdom, and we like ate all these drinks, and I ate so bad. So now I'm like, I have to make up for it.
How long do you have to do that? That doesn't sound fun.
I don't know.
Till you get to a magic number.
Yeah. Huh? What is your vacation? So we're not going like far anymore because we're scared of like what's going on. So we're just gonna probably go to like Destin now. So just be a couple of days.
I think I'm gonna send my parents there for that.
Destin's really nice. I went there a couple of
Yeah,
days ago.
they-
So the donuts are celebrating, what are the cupcakes for? You know I'm nosy.
It's a bribe.
Oh.
Who are we bribing? Bribing.
Is it working?
It did.
All I needed was donuts. That was it. That was an easy bribe.
Yeah.
Judge.
Oh, Lord.
Yeah, you didn't start.
So hold on 1 second.
that didn't show.
Okay, so no bench warrant.
Right.
All right. We have no deputy. Deputy Gordon? Sometimes hiding around the corner.
Yeah, he was here.
It's just here. Okay, I was just gonna ask him if Mr. Johnson was here yet.
Oh, that might be where he is.
I'm getting.
Go ahead. Yeah.
All right. Well, we have a bunch of folks on bond, so let's start with those. We have a final plea calendar. Ms. Nelson, is everyone on the April trial calendar? She might not have made it back to her desk yet. Let me ask that.
Yes, Judge, the April 23rd.
Thank you. All right, so if you're in court because you have a final plea date today and you don't resolve your case today, I will see you on April 23rd when we call the trial calendar for what will mostly be in May, but the April-May trial calendar. Position 1 is Darshir Brewington.
That case.
That's a diversion.
Do you agree with that?
Yes.
Yes, okay. As in Mr. Brewington was accepted into it?
That's correct.
All right, so he's got some number of months to take care of business.
Yes.
Trial diversion, all right. Mr. McWell, we've dealt with, he goes to the trial calendar. Kiara Boykin.
I expect her, Judge.
Okay, maybe running a little late. All right, how about Kelvin Moses?
He's in custody and that should be a negotiated PMC to talk to him.
Got it. I assume he's up, but we're deputy-less right now. Emily Browning.
Ms. Brown, she's present.
All right, everyone's here. Good. You have a co-defendant, and that's James Rayborn.
Because his dad, he's not here, his attorney's supposed to be on the way. Just speak with his attorney, Mr. Arca, he's on the way, should be about 1:30, so.
Okay,
I don't know where his client is.
got it.
Sir, I'm on the video chat.
Okay.
Yes, sir.
How do you pronounce your last name?
Rayborn?
Rayborn, I got it right. Okay, and your lawyer's on his way here?
Yes, sir.
Okay, well then sit tight.
Okay, thanks.
We dealt with Bradley Peoples, Natasha Scott.
This case was dismissed, Judge. I think it's filed, but I'll double check.
Okay, I think I saw an email about that. And Ms. Nelson said she was going to do that. Let me get back over here. Yes, done. All right. Jewel Nesby. Hi, Ms. Nesby.
She's mine, Judge. I just need to speak with her and then we'll have an announcement for her.
Okay. Barbara Joyner.
Remember, she did reach out to me. She said she had an emergency this morning, but she was going to be a little late, but she said her ETA would be like 1:30.
Okay.
And I was, well.
All right, we'll hold for her arrival. Tayshaun Johnson. Hey, Mr. Johnson. Good afternoon.
Your Honor, we would like to keep the final plea, but I don't believe I got an offer from the state. So we would need more time to negotiate. And so for now, I'm not guilty.
Okay, we'll circle back around to that one, but he's here, so we can take care of that. And then Jeffrey Keene should be in custody. You look surprised by that.
Yeah, I thought he was out, so I didn't talk to him.
All right, well, he's here. You'll be able to talk to him. And Deputy Gordon, you were busy, but is Kelvin Moses here? He's here. I think that was the only other. And then did Lonzie Johnson make it yet? Okay, we got a lot of people coming around 1:30. I'll believe it when Mr. Johnson's actually here. And is he coming over to resolve his cases? Whew. All right, let's see if we can do that. So I'm gonna let you all speak amongst yourselves for a minute. I have to go make a phone call. When I come back out, those that aren't working their case out will get on the record what the offer is, that it's being rejected, and we'll move forward. Or in that one instance, Ms. Rios, it may just be that we move it to the trial calendar, but we preserve the final plea rights. I will be right back. All right.
Feel some power going on. Consider, I mean, go to RZ, like say 5 years suspended, and she has to go in custody. He's going for suspended, so do we have any suspended? She says that's what police are saying.
You're saying, like,
Survey suspended. The other time, it's up to you. I'm sure. Since you did do
trying to go down her hair, like, buy it, or
yeah, that's what I started doing. But I was in there, that's
I got you. But if that happens, you're fine. We'll just follow that.
if she plays 2.
Yes.
I do 5. I'll just take the game. I would want to 5. Which I think you'd have to walk in, get the bank for those.
Maybe.
She just got us. I don't know, but somebody I keep trying to turn the key on that.
Literally.
Literally.
Okay, let me, for right now,
So I walk in, even just. It'll be 5 years or so suspended. I'm pretty sure she's going to custody. No, but I'm saying you have to go into county jail.
He's all in his room.
Okay.
I think so. I think so. So I told you guys. What I'm saying is that I told you. It's like, okay. Nobody suspended. Like it's like, or said that 5 years saying suspended on conclusion. That's what I think it'll be. Yeah, like she could. You get out. She's messed up. Don't do what I'm saying. She has to see 5 years. I think she would.
No, then I just did right there.
Yeah. And then, so she would go in, like, you do it. I'd ask the judge if we guys get a couple weeks. She's got more South to get her stuff closed out, but go into custody when she doesn't. So nice. And then she goes over and she would get out on probation. But whatever, 10 years or whatever.
Okay.
And then you get the first, I think she got 20 years. She misses it out.
Are you representing her case?
I don't think they're going to lie. And then you get my friend. To this on.
Say they're faster.
I fucking dying. Sometimes y'all good. Sometimes good. For some reason.
Okay. What I do is I was the other thing out from
yeah.
I'll discuss this.
Yeah.
You know, your time is wrong.
Here's what, we're the judge's manual, handle everything for you, so this shouldn't be your very long. Okay. Oh, thank you. It's what we talked about, nothing else. All right, good.
May I see the quote on the water?
Just trying to give you some ammunition.
Thank you.
Not that it's a secret.
Mhm.
All right.
Okay.
Okay, I'll let her know.
All right.
Appreciate it.
All right, are we in a position to handle any of the matters, whether it's just to work through the final plea rights or take a plea?
Then we're, there's some money, right, Judge?
Okay,
What?
Ms. Boykin. Okay,
That's just gonna be a final plea hearing.
all right, can you come on up to the podium, please, Ms. Boykin?
Yeah, I have video.
Oh, okay.
Oh,
I watched the video.
okay.
Stand right here. How are you? Good.
How you doing?
Good.
Good. Let me make sure we've got Ms. Rivers. We do. Ms. Rivers, you ready to take some things down?
Yes, I'm ready.
Great, thank you. This is position 3 on our final plea calendar. It's 25 SC 005 234. Ms. Boykin is in court with Ms. Wood. We have Ms. Smith for the state. Ms. Boykin, today is the last day that you'd be able to enter a plea in your case, if you wanted to enter a plea in your case, when you could withdraw that plea if the sentence you received was more severe than what your lawyer asked for. I'm going to ask your lawyer a few questions, the prosecutor a few questions, and then you, and we'll go from there. Ms. Wood, do you feel like you've got all the discovery in this case?
Yes.
Ms. Smith, what is the state's offer at this time to Ms. Boykin?
The state's current offer is 15 to serve 10 with the balance prorated.
All right. That's as low as the state can go without changing your charges or invoking a particular provision they can. So if you were to plead today, the state would be recommending that I sentence you to 10 years in custody, followed by 5 years on probation. And unless the state changes something about this case, Ms. Wood could not argue for any less than that. So it'd be 10 years to serve. Do you understand what the state's recommendation is?
Yes,
Okay. Are you interested in pursuing that right now?
no.
Okay. Then I'm going to move your case to the trial calendar. You'll be back here on April 23rd. You'll get notice in the mail and Ms. Wood will reach out to you, but I'm telling you now, April 23rd, it's a Thursday. I'll need you to be here so we can talk about if for some reason we have not resolved your case, maybe the state's offer has changed or you've decided, going to trial would be a lot worse than taking a plea. If none of that has happened, then we'll be figuring out when can we get you into court for that trial, which would be one of the 2 weeks right after that Thursday, the 23rd. Okay? So make sure you're available. The 23rd, it'll be first thing in the morning, 9 a.m. in this courtroom. All right? Any questions about any of that?
No.
Okay. Ms. Wood, anything else in connection with Ms. Boykin's case?
No, Judge, thank you. Yeah, I'm gonna talk to you in the hallway.
Ms. Smith, anything else?
Nothing further, Your Honor. Thank you.
All right. We can do Ms. Nesby or Mr. Blevins. Do you want to wait till Mr. Arce gets here, or do you want to go ahead and handle your situation with Ms. Browning? Okay, well, I'll see if Ms. Wood has one, and if not, then we'll do that. I think Nesby, other than Johnson, is your only other case.
That's correct.
Okay, Ms. Nesby, come on up.
Judge, I don't know if we need to do a full-blown final plea hearing. I shared with Ms. Smith, Ms. Nesby has given me some information today that I need to start gathering to get to Ms. Smith that could be helpful in reaching a resolution. So I think if we just preserve the final plea rights and leave this on the April 23rd calendar,
Yeah.
we should be able to have a resolution before then.
Okay, let's do that. So Ms. Nesby, I'm going to keep your final plea rights intact, which is your ability to withdraw from a plea if you don't like the sentence you get, because it sounds like you very recently have given Ms. Wood some information that she has or will be sharing with the prosecutor that might make the prosecutor think a little bit differently about the case. There's no guarantee of that, and so it could be when I see you next, which would be at the latest April 23rd, I'm saying, all right, what are we doing? And if it hasn't changed, the state may be making the same recommendation, and you'll need to decide, are you interested in that, or do you want to go to trial? It's not going to be a surprise what's happening on that day. Ms. Wood will have spoken with you before then, and it may well be that whatever information you were able to provide brings about some change in the way the state looks at the case. All right?
Okay,
Any questions about that?
no questions.
Okay. Are you supposed to stay away from someone or do something different while you're on bond?
Yes, I'm supposed to stay away from somebody.
Okay. And are you doing that?
Yes.
Okay. We'll keep doing that, and I will see you at the latest on Thursday, April 23rd.
Okay.
Ms. Smith, anything else?
Nothing further.
All right.
Thank you, Judge.
All right, Mr. Blevins, why don't you and Ms. Browning come on up, please?
Good afternoon, Judge.
Good afternoon. Good to see you again.
You too, sir. Been a while.
It's been a minute. I don't know much about this case. It's gone from arraignment to here we are at final plea. But we're going to get on the record. This is 25 SC 005315. We have Ms. Browning at the podium with her lawyer, Mr. Blevins. Ms. Smith is handling the case for the state. Mr. Blevins, do you feel like you've got all the discovery in the case?
I do, Judge.
Okay. Ms. Smith, what's the state's recommendation to Ms. Browning?
In this case, Your Honor, the state offered a deviation of 10 years to serve 5 with the balance probated with the condition that Ms. Browning complete RSAT while in custody.
All right. So, Ms. Browning, you heard when we had Ms. Boykin up at the podium that I said, you know, this 15 to serve 10 is as low as the state can go unless they invoke this special provision. And it sounds like in your case, the state is willing to do that. There's some circumstances about your case that makes the state think that you have some connection to the armed robbery, but maybe you weren't the one with the gun or who knows what. And we're not going to get into that today unless you're working the case out. But the state is willing to deviate below the 10-year mandatory minimum. If you go to trial and you're found guilty of the only charge you face, which is armed robbery, unless the state asks to deviate, I can't go below the 10 years to serve. So that's the lowest sentence you would get if you went to trial and if you're found guilty. So a couple of ifs, but it's out there and you need to know that. I'm sure Mr. Blevins has told you, but it's a real serious charge in Georgia. And those are non-parolable years. So someone who goes to trial and is found guilty of armed robbery, the shortest sentence they can get is 10 years in prison to the door. You could be the best inmate on planet Earth and you're still doing the 10 years. I share that with you not to encourage you to work it out. I just need to make sure you understand the landscape. But the state is willing to offer you less than that. It's 10 years to serve 5 years with a balance on probation. With a recommendation that you get some substance abuse treatment while you're in custody. 5 years is still a long time. Do you feel like you understand what the state is offering?
Yes, sir.
Okay. Do you understand that today you could withdraw your plea if I sentenced you above what the state's recommending. So if I said 6 or 7 or 8 or 10 years to serve, you could say, nope, the deal was 5 and I was willing to do that, but I'd rather go to trial if it's more than 5. You understand you can do that today?
Yes, sir.
After today, you can still enter a plea, and Mr. Blevins is going to continue to work hard on your behalf to maybe get that number even lower. But during that, at the end of that plea, whatever it is, I'm going to say, here's your sentence, and you don't get to withdraw if you don't like that sentence. So today would be the last day you could back out if you were unhappy with the sentence. Do you understand that?
Yes, sir.
Okay. And you feel like you understand what the recommendation is?
Yes, sir.
All right, understanding all those things, Ms. Browning, do you want to resolve your case today, or should I move it to the trial calendar?
The trial calendar.
That's what I'll do. I will see you again on the 23rd of April at the latest. That's the day we call the calendar. If the case works out before then, I'll see you then. But if there's not any movement, then you'll need to be here with your lawyer in the morning of the 23rd. And I'll ask one more time, have we worked this out? And if the answer is no, then we'll figure out which of the 2 weeks makes sense for us to do the trial in the case. All right? Mr. Blevins, anything else on behalf of your client?
Not this time, Judge.
Okay. Well, if there isn't anything that changes, I'll see everyone on the 23rd.
Yes, sir. We'll keep pre-trying with the state.
All right. Ms. Smith, anything else?
No, Your Honor.
You're welcome.
That's all I have, Judge. May I be excused?
You may.
Thanks.
Yes. Yeah. Okay. Yeah, that one is probably gonna be good now for 3 months. I'll double check all of that, but, I'll let you know. But yeah, that's my goal. Thank you.
I don't mean to keep people waiting around. I think we've got Mr. Johnson, who's not here yet, and then the rest is Rios, until we get Mr. Arsa.
Yes.
Okay.
So fun, it was important. I'm gonna talk with her.
What's that case about? And she doesn't strike me as a typical armed robber.
It was alleged her and another person went to, this other person committed the robbery, but she was the only one picked up for it. They pushed her, who the other guy was, and we didn't get it.
So it was a guy and a gal. She was the gal part of the.
Yes.
Okay. I mean, similarly with Ms. Browning, doesn't strike me as the typical, but here we are.
Judge, how you doing?
I'm well. How are you?
I'm doing fine. Julian Jordan was coming to say hello.
How's he doing?
He's doing good. He's over in college.
He is.
Lovely. He's about to have a baby. Yeah. So he's about to be done.
Good for him.
So
We miss him in Fulton.
that's what he probably said he'd say. But I'm here on Rayborn, Judge.
Yes, and he is online, so we are going to get him to turn his camera on, and we will see what we can do. There he is. Let's add the spotlight. There he is. Okay, if you just come on up to the podium. This is on for final plea. We handled the final plea for Ms. Browning, the co-defendant. She declined the state's offer and asked the case to be moved to trial. Trial calendars, the call of the calendar is April 23rd.
Okay.
And it's a 2-week calendar, I believe, that starts that following Monday. And so we just need to make sure, one, well, we're going to get on the record and we'll handle it that way. So this is 25 SC 005315, part 2. This is the co-defendant, Mr. Rayborn, who is appearing virtually. His lawyer is here in court, and Ms. Smith is here for the state. First question goes to defense counsel. Do you have all the discovery in the case?
It's my understanding that yes, I do.
As best you can tell.
As best as I can tell. I've got pictures from the bank. However, I believe there's no video from the bank. That's the only thing I wanted to confirm with the state.
Okay.
Other than that, I believe I have everything else.
All right. I'll let you confer with Ms. Smith afterwards. And if there's video, I'm sure she'll get it to you if she's got it. It doesn't sound like that's anything suppressible, but it's certainly something you're entitled to.
Correct, Judge.
As you figure out what your defense is going to be. Ms. Smith, what is the state's offer to Mr. Rayborn if he was going to resolve his case today?
Yes, Your Honor, the offer in this case is 10 years to serve with the condition that he enter and complete the RSET program while being in custody.
So straight 10 years.
Yes.
Got it. So Mr. Rayborn, 10 years to serve is the minimum in an armed robbery case. That's what the state is offering, and they are asking that I recommend. I don't get to tell the Department of Corrections what to do, but I recommend that you get some drug treatment while you are in custody. Do you feel like you understand what the state's offer is?
Yes, sir.
Okay. Are you interested in pursuing that at this time?
No, sir.
Okay. I'm going to move your case then to the trial calendar. Where are you right now? What city are you in?
Eastman, Georgia.
Okay. You will need to be here on the 23rd. It's fine that you're appearing virtually now. Eastman is not near. But when we are calling the trial calendar, I need everyone here so we can map out what we're going to do. That is Thursday, April 23rd. Your lawyer will be in touch with you well before then to talk about what's going on. He will continue to work with the prosecutor to see if there's a way to sort this case out short of trial. But if there's not, then we will figure out which of those 2 weeks makes more sense for the lawyers involved. Ms. Smith, do you envision trying the defendants together? There's no motion to sever right now. Is your view that they are triable together, or is there a statement from one you're going to use against the other?
Right now, we see that they'll be tried together.
Okay. Then we just need to make sure, Mr. Rayborn, that I can get both defense attorneys here for one of those weeks as well, because they've got cases all over the state. But that's the plan. Anything more from the defense?
No, Judge, I was just going to ask about the trial calendar and trial weeks. I've got a special set in Judge Atkins over in Gwinnett. That's the last 2 weeks of June. That's specially set. So I just wanted to know more or less to get an idea as to, am I really going forward at the end of April? Because I know sometimes depending upon people pulling out, things changing.
Right.
Whether it was realistic for April.
So April 23rd is when we call the calendar. Oh, it's only a 1-week calendar. And the week of trial is the week of the 27th. So it's got 1 day of May in it, but it's the week of the 27th. So that's not going to interfere with your Gwinnett trial at all. It's more than a month away. But that means we'll only be able to try one case. Is it this one? Is it another one? TBD. I don't leave you guys guessing. When that calendar is published, we'll all take a look at it and say, you know what, there's 7 murders on it. We're probably going to do one of the murders before we do this, in particular because your clients are on bond,
Right.
which doesn't make it less important. It just means they aren't dealing with incarceration. But I don't want to commit to that now because I don't know what's on the calendar. And
Completely understand.
I may get told by lawyers on the murder cases, I have to be in Gwinnett that week.
Correct.
So I would view the week of the 27th as trial week.
Okay.
But you are free to reach out once that calendar is published to say any guidance as to what might go first or second. I'm not aware of anything being specially set for that week. Sometimes I'll have on that calendar one that I know is specially set because it's a speedy, or the lawyers have said, all our witnesses are coming from Minnesota and we need to lock in a specific date. I don't think we've got that on this calendar.
Understood, Judge.
If it isn't reached on this calendar, sometimes we roll just 1 month, sometimes it's a 2-month roll because Ms. Nelson's already built the May calendar, so it might leapfrog to the June. Then we might be running into your Gwinnett situation. But if that case is older, that's where you need to be. And we would not want to put you on a calendar in June knowing that you couldn't be here.
Right.
So we'll work with you, and you just need to let Ms. Nelson know, these dates, they're not going to work.
Thank you, Judge. I appreciate that.
You bet. Mr. Rayborn, do you have any questions about process or scheduling?
No, sir.
Okay, well, we'll see you here on the 23rd.
Okay.
All right, thanks for dialing in.
Thank
Yes,
you,
sir.
Judge.
Thank you.
May I be excused?
Yes, sir.
Thank you. We'll talk. Good to see you.
Good to see you.
Go ahead.
Now I get it. Someone said he's the dad, and I'm like, that man is not the father of Miss Browning. That man is the father of Mr. Rayborn. Got it. Okay. That fits. Was it a bank robbery?
The victim in that case.
So when
Yeah, that case. Of who?
Okay.
It's a bank robbery.
What?
We never get those. Those go federal. Oh, they're all the time, but they go federal. The feds grab those like that. That's the notes and real guns and fake guns, finger in the pocket. No, you'd be surprised how often there are bank robberies and how often they get money with a die pack that goes off. And so then which person did it? It's the guy with red paint all over his face. That's what, as a new AUSA, that's what you would try is the bank robberies, because you basically just show the picture of the guy with red dye all over his hands. It's because, it's a hoodie, you're wearing a hoodie, and you shove the money in the pocket of your hoodie, and then the die pack goes off, and it's just red everywhere. All right, so is Ms. Rios in the back? I'm gonna let her talk with folks. Mr. Johnson, we're not forgetting about you. It's just Ms. Rios is talking with a couple other clients who are in lockup. When she comes out, we'll take care of your situation as well. All right, I'm gonna go back and do some work. Just let me know when I should come out, and we'll knock those out, and let us know when Mr. Johnson is ready to go. Do we need to call to confirm he's coming?
I told him to let me know, call me when he's down.
Okay,
He's en route.
got it.
That's how much it.
Okay. En route's a good thing, though. That mean, and you believe it?
You just make a call.
Okay.
Mr. Johnson around here? You know, Brandon? Yeah, she ain't awesome. Let me know. That's, oh, yeah.
Judge, in the email this morning, so saying that, there's a bill that's been passed in the House
Got your message.
that they're creating another judicial seat for this circuit.
We call it the 21st Judge Bill. It passed unanimously on the House side.
So it says, sitting with the Senate and.
The hitch is the Senate. We're trying to merge it with, there's already a bill for the other three judges. I can't remember what's Middle Circuit. I think Gwinnett's getting another, there are three circuits that are getting another judge. And if we can just tuck in with that, it'll make it easier because the legislature usually approves 3 a year just based on growth in Georgia. We've been due for a while. And we finally got some legislative traction. So the hope is we can pull it off. And there should be some money in the budget for it. So we'll see, but we could use it.
Go for a Superior Court.
Oh, it's a Superior Court judge. It's a 21st Superior Court judge. So it would add one more, and then that person would be down on one of the first floor courtrooms. Yep.
Who's in trial in front of Judge Emerson this week, do you know?
Yes, Minter is the defendant. It's an attorney who works in the defense attorney is the Robert James office, but this guy I've never heard of. It was not a name I recognized, so he is an attorney in the Robert James firm, and Ms. Charles, K. Charles is the prosecutor. Yep. Oh, and I intentionally didn't put Daniels on the short list for next week because I was told that on Thursday it's likely being resolved. Still likely being resolved?
I don't know exactly which, Ms. Nix gave us options, so I'm not sure which.
A menu.
Yes.
Okay.
But I'm expecting it to resolve and Ms. Primblick is gonna meet with me just to seal the deal.
Great. And Mr. Daniels will be here in person?
Yes.
Okay.
He has booked a flight.
Great. Thank you.
I didn't get more regularly. Oh, I don't want to get. Passing it again, stating.
Pardon?
Passing it, say it again.
Oh, great. Excuse me.
It was on body cam footage or anything for him. That's in evidence that, because he's saying that he would raise his fist against the officer. I think it's really missing the illustration. But it's he's a officer that when she because he was had that when he was old. And my client said he has a witness saying that he didn't punch him. So I'm going to be requesting for it to be reduced to a misdemeanor.
Okay, there, I looked in there too, they don't have body cam. I requested it, we haven't gotten anything back, but I don't think. But if it's the witnesses for the work for the.
Yeah, they're looking at, so I'm not sure, I thought we were gonna have something too. I was thinking village public place, because he didn't, he didn't. I didn't know. I was saying just.
Had to go to the
Tussle.
hospital.
Yeah, and the tussle, which it wasn't, he wasn't resisting, it's pulling away, which he could have gotten injured like that, but.
Brandon saying he never threw a punch.
Yeah.
Okay.
Because he doesn't have anything before this, right? It's this and then the case that he's in for right now, which doesn't make sense because he didn't have any drugs or anything in the car, so I don't know why because he is in one of those.
Which is, it's very honest. So I have the first and so the whole thing is how they can get. Yes, I don't need instruction. But it's best to get.
It's the other person already indicted.
It got indicted, so I'm hoping I can get them indicted. But only thing is, the fleeing, even if a first offender, is there any way around that mandatory view?
Only way to get out of that is in law property and indicted as a misdemeanor. If it's indicted under A, then it can't be a misdemeanor, but if it's indicted under C, only way you can do it is if you know property and then re-indicted. But.
I'm sorry.
Ms. Joyner?
Yes.
That's okay.
Well, in the meantime, because what is he gonna be doing this? Final appearance?
I think,
Since he wants to do the law,
Yeah.
In the meantime, before we get on, before we're on the trial calendar again, I'll follow up with, my witnesses too, also looking to get footage from the place of the, I don't even know what it was
Well,
called.
we're not gonna do a final plea because I think we're actually keep it open since there's so much
Oh, preserving his final plea rights.
Yeah, so we won't keep it hearing because we need to see if we can get some videos because they have different stories.
That's fine with me. I'm sure that this is something we will resolve before the trial calendar.
Yeah.
So, I'll send you a waiver to sign for the PI case. And then once I get a chance to either you get the footage or I do, or even if they, well, I guess we find by then. We'll go from there. Is he's a cousin?
Yep. You think that's the other PI case. I think, I just don't feel like in these situations, like it should happen to a year.
Is it indicted under, well, it's not indicted yet.
So because maybe we could do a felony on this case and a misdemeanor on the other case. If it can be re-indicted, because it's not even indicted yet, is there a way to indict it under a misdemeanor?
I'll check with, case intake.
Okay.
Because I think, I don't know if I catch it first and accuse it, can it be charged differently that way, or if it can be charged differently just for case intake?
Okay.
But let me see what we got first, the warrants, what happened.
Okay.
And we should definitely get most of that before April 23rd.
Yeah. What's going on with everybody else?
We're waiting on Johnson and then.
Moses is ready for his. Did you see any other open cases for Moses? Can you check? Because he kept saying he had another case, but only other open cases I see was, everything was closed. Kelvin Moses.
Ms. Simpson, do you serve in other counties or are you just exclusively in Fulton? Okay.
How are you gonna take me?
Nowhere. I was just wondering because I know when we have like defendants that got probation in other counties, I was wondering, do y'all just partner with those other counties or how are y'all able to, or is it a system?
Yeah, our agency is statewide.
Okay,
You just have different servers.
okay. If it's other states, how do y'all?
That's where ICOTs come into play.
Oh, yeah, okay.
Just the same as, person would have to do an application and our field office would have to contact that state. Same thing goes here, vice versa.
It has to be transferred.
Contact us to see if we will be able to supervise that person here.
Okay.
And that's been, because we're such a large county.
Yeah.
So,
Okay,
yeah.
good to know. What's I have to do just now? I wanna know what else. Guys,
This is funny.
Who represent Johnson?
What's the first name?
that's Lacey's client. Wanzi Johnson.
So if we could get that other piece to be misdemeanors, he would plead a felony on this, take this, then on this, and the other piece would be misdemeanors, and we can do a global resolution.
Okay, his goal is to have at least one of the cases be a misdemeanor, so he's using first.
Yes.
Okay. I'll look.
And I
through
figured it would be
everything.
easier for this, because this is kind of mandatory versus the lenient.
Okay. I get what you're saying. I'll look through everything. I'll let you know.
Okay.
I'm not giving, I want
It's
to
so
give you
stupid, I
a
was just kind of like, I mean, first of all, they're connecting it through him, through somebody else. Someone else that called and saying it was him. That's how they're connecting it, so I don't even know who was him, but the person they're saying was clean. Like, it was really marijuana or anything like that, they're just saying that he was doing some weird traffic stuff. And then, they asked him to stop, and then he just kept going. And he hit somebody in the middle of the road, or hit some,
So was it like a,
hit the police car's front when he was trying to get away.
was it like a traffic stop?
Yeah, because he was like trying to make a left turn, couldn't make a left turn, and they were trying to stop him.
Oh, okay.
And then how they didn't even know, when they looked at who the car was registered, it was to some rental company. That rental company gave it to some girl was like, he is the one who I would give the car to, and it was like some text messages there. But before that, he didn't have any history, he was working at the Congress where they let him come back. So I was just like, I don't understand what, it's not like he had, and he's 26, not like he had a lot of stuff,
Who
so.
was in the car with him?
He's, who was it when he was driving?
On the plea case.
I don't think they said anyone that was in the car with him.
Oh, he played on foot. Wait, what?
No, he got, the person got away, that's why they had to connect it through the rental company.
Oh,
Yeah.
like he wasn't arrested on that day for it?
No.
Okay, I get what you're saying.
Did you find anything on Moses?
Everything we had is closed.
That's what I told him, okay, so we're good to take his plea when judge gets back.
What are you doing?
What are we waiting on? What
What are we waiting on?
Johnson?
Or
Judge Well, I'm back.
She wants to jail talk to your client.
First of all, I didn't know he was in the jail. He was arrested 2 weeks ago. I just been calling. Yeah, I was like calling his phone. I was like, why he not answering me no more? I forgot to check the jail.
You got to check.
Yeah.
So do you check like the week of your calendars or how you?
No, I usually don't. I need to now. From this, I'll start from now on. If they're not answering me, just assume they might be in the jail and check the jail before I just.
Assuming he's just not answering. your
Yeah, I just assume like, oh, I guess he won't talk to me no more.
Need to get Gordon to find Marcus Smith.
Huh?
Need to get Gordon to find Marcus.
Yes.
Smith.
Who's Marcus Smith?
A client that that's lost somewhere.
He's lost somewhere.
I called. I think he's supposed to be outsourced to
He
Cobb.
did his plea a year ago.
It was a year ago. It was like four. It was a 4 month. It was a year ago. He was sentenced to a year, but it was like 2-3 months ago.
He's probably down the road.
No,
I don't think so.
he shouldn't be.
Wow.
Because
got a year.
he got a year, but he only had 4 months left to do from the year.
They send you down the road for 2 weeks,
what?
3 weeks, love.
Oh
They send you
man,
down the road.
let me check.
Check down the road. I'm sure that's where he's at.
Yeah, check because he was sending me a letter fussing at me, so I was trying to like
Where the letter came from?
Cobb, and then I sent the letter thing back to Cobb, and I tried to do a video visit to Cobb, and they were like, he's not there. I called full, and they were like, you should be in Cobb. Cause I'm like, okay, well, they said he was.
Marcus Smith?
Yep.
Send me the wrong. Wait, make sure he's not down the road first.
Now let me see. Where he is.
Well, I'm 98% sure he's down the road.
Well,
He was over the year with 4 months left.
it took a while to send him down the road.
Yep,
Oh, he is.
he is.
When you see it, open the door.
Ms. Rios?
Good job.
Yes.
What would you like to do next? You've got 3 cases,
So.
Joyner, Johnson, Keene. You may have more, but those are the 3 I see right here.
Well, we can get Joyner and Johnson out because we gotta get any notes from anybody for them.
I have not. I haven't got
I don't have offers, so we can just do with them on the.
Wait, there are people on the final plea calendar you don't have offers for?
I believe I do.
Ms. Smith,
That's not her.
they're not your case? Oh, then one of them's not your case.
Thank you.
Joyner's not.
I don't think Johnson is either. I was trying to check.
Oh, is that a Willingham case?
I think so.
Give me a second. I'm gonna.
Okay.
Well, I wasn't ready on a plea for Moses though.
Say that again?
I'm ready to do the plea on Moses when Mr.
Oh.
comes back.
Okay. I didn't hear you say anything about Keene.
Keene, so he is in custody on a new case, and so we're trying to do a global resolution. So I'm hoping that we can just have it worked out by the time the trial calendar comes up.
What are the new charges?
Fleeing and attempting to elude
Okay.
and some other hit and run type charges.
The aggravated battery on the law enforcement officer in the case we've got right here. What's the gist of the allegation?
Fighting an officer.
Biting or fighting?
Fighting, like
Okay.
resisting. I think it's more of a misdemeanor.
But the aggravated, it's not like he poked his eyeball out or something.
No, they're
Okay.
saying- that's why I don't understand why. Let me look at the indictment because I don't even think the aggravated aggravated part was indicted.
Okay.
Let me see. I think it's just the felony obstruction.
Yeah, it's on. Oh, no, you're right. It's all it is willful. So it's just felony obstruction,
Yeah, they're saying that he like swung at the officer.
Okay.
Video.
which sounds work outable, but you say he's got these new charges and so you want to try to do everything.
Yes.
Okay.
So we can use he has no felony history, so I'm going to give you first offender on one and misdemeanor on the others. Let me see. Does she have it?
Give me 1 second real quick. In Johnson's case, I think the victim is I don't know who the relationship, but they're not in an intimate relationship, so it won't be DDs. So I guess it'll be Charles, but it's obviously as DDs.
Will be yours for Johnson?
I think so, yeah.
Oh, okay.
But I'll send out an offer for this case. Yes, as soon as possible.
Okay.
Yeah.
And who would join her? I already saw
Joining
it.
is Nick's.
Yes, of course.
That's Nick's case. But
I knew it was not like when we had to give me not have an offer. She always has offers. After clearing.
yeah, I don't know why it's on Odyssey as like DV's case though. So that's why I think touch it with mom.
Okay, no, it makes sense.
I'll get you an offer.
Okay.
I don't mean for you to be trying to track people down. If we just need to move Ms. Joyner and Mr. Johnson to the trial calendar, I'll keep the final plea rights open. And Ms. Nix has been hard to track down recently. I don't know if she's been in lots of trials. I know there was one, but that's been over for a little while. So.
And it's not, none of these are Willingham. Let's not slander her name. She gives offers right after.
I'm not slandering anyone, but I was surprised that there was a Willingham in the mix. So who has position 11?
11 will be mine.
So we should slander Smith.
Well, she thought it was TV.
No, don't slander me out.
Okay. But you ought to be in a position to have a conversation about how the case would resolve, or had you not been working on it because you thought it was another unit's case?
Right, it was assigned to another unit. It wasn't.
Oh, when did it get pushed back on you?
When I read the facts, it wasn't like DV, it wasn't like a boyfriend, girlfriend living together, they have kids. So sometimes it's indicted, it goes to a division that it shouldn't be. So it wasn't assigned to us.
Okay.
I'll look into that case and give Ms. Rios an offer.
Okay, well, we've got Mr. Johnson here, so let's just let him know that we're moving his case to the trial calendar, but we're preserving his final plea rights. So I will see you at the latest, Mr. Johnson, on April 23rd. Did you get something in the mail telling you to be here today? You'll get something in the mail telling you to be here on April 23rd, but well before then, Ms. Rios will reach out to you to talk to you more about the case. And maybe it can be worked out before the 23rd, but the 23rd would be the last time to work the case out where you've got the ability to withdraw your plea if you don't like the sentence that you get, okay? But that's a month and a half away. There's lots of time to make some progress on the case. Do you have any questions? Ms. Rios, do you have good contact information for Mr. Johnson?
Yes, you're right. Did you see that text I sent you? So, okay, just making sure your phone works. Yes.
Okay. Do you need Mr. Johnson to stick around?
There.
All right, you're good to go. Appreciate your patience. Sorry we weren't able to do more today. Yep.
Ms. Rios, he's in call.
Marcus Smith?
Yes.
Who is not. I have called.
He's alone now. He's outsourced from us to call.
Yes, and they say they don't have him.
They just told me to call.
They someone lost him. I give up. But thank you. Hopefully he'll be somewhere. I'll see him on the street whenever he's late. I try.
Hopefully he show up at our office at some point.
Oh, well, that too. Oh, I guess we can let Miss Joyner go too, huh?
Have you talked to Megan about the Joyner case? Have y'all had communication with her?
Is Ms. Joyner here?
Yes, she's here, right? Miss Joyner's here.
Hey, Ms. Joyner. So same situation, you just don't have an offer?
That's right.
Okay. Ms. Joyner, the prosecutor who is working on your case has been tied up in other courtrooms and hasn't been able to give Ms. Rios whatever recommendation the state has to resolve your case. That's not your lawyer's fault. It's certainly not your fault. But it means we can't do today what I had hoped we were going to do. So I'm going to preserve your final plea rights, which is your ability to back out of a plea if you don't like how it goes. And you may not be interested in entering a plea at all, and we'll get you a trial, but you may want to work it out. And I'm going to keep that right open for you all the way up through the date of your trial calendar, which is April 23rd. So you'll need to be back here at the latest the morning of April 23rd, and you'll get something in the mail reminding you. And does Ms. Rios have all your contact info? Good, she'll remind you as well. But she's going to try to connect with this prosecutor to say, hey, could we work this out? What's a reasonable situation? And then Ms. Rios, of course, would talk to you about that. And if you guys reach an agreement, we can have you come in well before April 23rd. But if we don't do that, then I need you here the morning of April 23rd, and we figure out, all right, when are we going to try the case? All right? Any questions? Do you need Ms. Rios to speak with Ms. Joyner anymore?
No, you're right.
Okay, all right. Thank you, ma'am. So that leaves Keene, but you know we're not resolving it today because you want to get the other case to catch up.
Yes.
So I guess if we can just bring him to the door, and then we could do Moses once Ms. Smith comes back in. And then is Ms. Wood talking to Johnson right now?
He's outside.
Oh, okay.
I think she did off the street. So they have a definite answer in about 10 minutes
About what?
to where he's at.
Oh, thank you.
Does the person she's claiming is not in Cobb?
He's in car. I don't know what the car is.
Yeah, I tried to do several video visits.
He took a plea in January, we're just trying to go.
Well, he had 4 more months left, but the credit, I don't know, trying to figure it out.
Hey, Mr. Keen, how are you? Good. I'm Judge McBurney, and we should have met before on this case, which is your obstruction of an officer case from way back in March of 24. You have a new case as well, and because of that new case, Ms. Rios, your lawyer, has asked that we tap the brakes on your older case so that the new case can get charged and you can try to resolve everything all at once. Makes a lot of sense. It would be too bad if you resolve the older case only to get pulled back into the system to deal with the new charges. So that's the plan. Is that what you and Ms. Rios talked about? Okay. Do you have any questions for me? Other than how quickly can we do this? And Ms. Rios will be working with Ms. Smith, who just walked into the courtroom, to try to get what are the new charges?
Playing intent.
Oh, you mentioned that. Some kind of
Traffic stuff.
driving away from the police. Ms. Rios is going to try to get the district attorney's office to charge that. Then you'll have both cases that'll get assigned to me. So you're with same judge, same lawyers, et cetera, and we'll figure all that out. Okay? All right. I'll see you soon. Oh, wait, one last thing before you go. Ms. Rios, just in terms of timing, should we move Mr. Keen's case to the trial calendar, month and a half away, preserving his final plea rights, because hopefully the other case will catch up by then? Or do you not want to crowd the trial calendar with that because the other charges may still be out there?
Let's not, maybe the inquiry
Okay.
around in that same week, you think it get done by then?
Mm-hmm.
Okay, so not to the trial calendar, put it on an inquiry calendar to see if we can get the 2026 case brought on board.
Yes, sir.
Okay, all right, sounds good. See you soon.
Your Honor, I did speak with Ms. Nix regarding position 10. She said she did get a chance to look at the case, but she is not sending an offer to Ms. Rios as soon as possible.
Okay, and is Ms. Nix in trial right now?
I don't think so,
Okay,
but I did not confirm that.
all right.
Are we doing?
Yes.
So I think we'll do the plea of Mr. Moses now. Can we get Mr. Moses, please? Thank you. Give me 1 second and we'll get started. Okay. We are going to get on the record now. This is position 4 from the final plea calendar, State versus Kelvin Moses, 25 SC 005-239. Hello, Mr. Moses.
What's up?
How you doing this afternoon?
Okay.
Good. It's good to see you. Ms. Rios tells me that you are ready to enter a plea in your case. Is that right?
Yes, sir.
Okay, we're going to do that. Ms. Smith, who is seated to my left, is the prosecutor on your case. She's going to swear you in a moment and then ask you a bunch of questions about you and your case and your rights. I need you to answer those as best you can. I also need you to tell me if at any time you have a question because something confuses you or you didn't hear someone or for whatever reason. Will you let me know that you have a question?
Yes, sir.
Sounds good. We'll try to get through this. Ms. Smith.
Yes, thank you. Mr. Moses, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Kevin Morris Mosley.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
43, 7th grade.
7th.
Yes.
Are you able to read, write, and understand the English language?
Yeah, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yeah, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yeah, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yeah, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Moses, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yeah.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yeah, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yeah, ma'am.
Are you currently on probation?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Wow.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Moses, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 005239, how do you plead to count 1, burglary in the second degree, count 2, criminal damage to property, and count 3, entering an automobile with the intent to commit a theft?
Yeah, guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, yes, ma'am.
Do you understand that you do not have a right to appeal your guilty plea, but if you feel like there's been an error in your guilty plea, you can apply to the appropriate appellate court for a discretionary appeal? Do you understand that that has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge? to file a habeas corpus petition challenging the voluntariness of this plea. All right, thank you, Mr. Moses. Your Honor, in this case.
Was that a yes as to the last question?
Can you repeat the last question?
Mhm. Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes?
I don't know if you can.
Okay, but then that's when you should ask, is if you've got a question. So what Ms. Smith is explaining is, if I accept your guilty plea, which I think I will, after I sentence you, you have 4 years in which to file an appeal. It's called a habeas. It's a civil case, but don't worry about the technical words. You have 4 years to challenge if you are unhappy with the sentence and think that there was some legal error. And so she's just giving you that deadline. I don't have a reason to think that you're going to want to appeal, but if you do, she's letting you know you only have 4 years. And she's only recommending a 5-year sentence, so they're pretty close in time. But if you were to wait till 5 years out to say, wait a minute, I'm unhappy with this sentence, I want to file an appeal, that would be too late because 5 years is more than 4 years. Does that make sense? She's just letting you know you got 4 years to bring that challenge if that was something you wanted to do. Okay? All right.
Thank you. Your Honor, if this case were to proceed to trial, the state would show that on May 8th, 2025, officers with the Atlanta Police Department responded to the incident location of 845 Spring Street Northwest, that's in Atlanta, Georgia, and also in Fulton County. They got the call regarding a business burglary. When they got there, they spoke with an employee of the Rambler. His name is Dave Schaefer, Shaffer, who advised the officers that he was doing his rounds in the building when he saw a window that was broken because a large brick was thrown inside or thrown against the window. Mr. Schaefer advised the officers that he checked the camera and saw a black male wearing all black and a white undershirt and a backpack approach the window at approximately 12 a.m. Took a brick out of that book bag again, threw it at the window. The officers were able to also look at that camera footage, and at that same time, well, from that burglary, Your Honor, the officer said that in the video, the defendant took several bottles of syrup that was used to flavor coffee and put them in their backpack. The defendant was not arrested at that time for that burglary. However, later that day, the officers did put out a bolo based on a photo they had of the defendant, and Georgia Tech Police responded and spoke with the officers to tell them that they had someone who was detained based on that description. When the officers got there, Georgia Tech Police told APD that the male that was matching the photo from the bolo is the same person they had detained for a car break-in. This car break-in was the same type of method. A brick was thrown inside of a car. The car was rumbled through, but nothing was taken but I believe a backpack and a pink coat. At this time, the defendant was taken into custody for the charges we have in front of us. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, the state and defense has agreed to, for counts 1 through 3, a 5-year probationary sentence, all to run concurrent. Regarding the special conditions of probation, the state is recommending that the defendant work with Pat, is my understanding, speaking with Ms. Rios, that he's been accepted to work with them and get some assistance from them. Also, the state is recommending that the defendant complete an anti-theft course for the defendant to stay away from the incident location of the Rambler, and also for the defendant to pay restitution to the victim of the auto theft break-in. Her coat and her book bag was taken, but we will ask for that restitution to be reserved because we have to get receipts and actual copies of what was stolen from the car.
Okay.
But that's all from the state, Your Honor.
Understood. So this address on Spring Street is, it sounds like it was part of Georgia Tech. Because you mentioned Georgia Tech Police and Rambler, that all fits. Maybe a condition of just stay off of Georgia Tech property?
That's fine. Yes.
Okay. We'll talk about that. All right. Thank you for that. Ms. Stallworth, good afternoon. Do you have criminal history? First, is your computer working?
Yes, it's back.
Excellent. Do you have criminal history information for Mr. Moses?
Yes, Your Honor, I do.
He has 13 cycles total, 2 of those cycles from the state of Texas. He has a 2019 conviction for arson first degree and criminal damage to property first degree. He has a 2024 conviction out of Cobb County for possession of methamphetamine. He has 2 outside of the 10-year period, one in 2012 and one in 1998. There are 2 active warrants, one out of Dunwoody for an FTA. The date of that warrant is June the 5th of 2025. And the other is from Clayton County, also for an FTA. Date of that warrant is September the 30th of 2025. Nothing further.
Thank you so much.
You're welcome.
Ms. Simpson, is Mr. Moses on probation for that 2024 methamphetamine case?
That case is closed as of December 24th.
Okay, so nothing active. Got it. But it looks like there may be a couple holds on Mr. Moses. Was that news to you, or you knew there might be at least a hold?
I didn't remember seeing a hold, but maybe it popped up more recently.
Okay. There's not one showing in Odyssey. It doesn't mean they aren't out there, but okay. All right. Mr. Moses, do you have a case in Clayton County? Does that sound familiar?
No, sir.
No? Okay. Maybe you do. We're not sure. Do you have any questions about, oh, well, Ms. Rios, let me turn to you and then I'll ask Mr. Moses.
Yes, Mr. Moses is 43 years old. He has struggled with housing, mental health, and drug addiction. I did refer him to drug court, but they did not accept him. And so that's why my Ms. Ross set up him with PAD, so he'll be able to go there for housing and mental health.
Did they say why they did not, what did Accountability Court provide any?
I need to double check. Honestly, they've been rejecting everyone that I've been sitting lately, so they're very strict nowadays. So I can't remember the particular reason. It might have been because I think they're rejecting anyone with extensive history, but I didn't think his history was.
Having heard, well, I mean, maybe the arson, but the others don't sound like that.
Oh, there was one charge in its past that they said that was the reason they didn't reject.
One of these that Ms. Stallworth said is more than 10 years out.
Right.
Okay.
So he'll be able to get the services through PAD. I'm asking for the fees to be waived since he does not have income. And I also was going to ask for a behavioral incentive date of 2 years. If PAD helps him get on his feet, hopefully he will not be back in court with us.
Okay. I cannot make PAD a condition of probation, so I can encourage Mr. Moses to do that, but PAD
Yes, Your Honor.
won't work with Mr. Moses if it's a requirement as opposed to an opportunity that he's gonna take advantage of. Mr. Moses, do you have any questions about anything we talked about?
I'd like to know where I got a hold of that.
Well, you may have a hold, and there were 2 places that Ms. Stallworth mentioned.
Clayton one is for a misdemeanor.
Okay, but you're seeing it as well?
Yes, Judge. It was issued September 30th of 25 for misdemeanor criminal trespass.
Okay, and Ms. Stallworth gave that same date. So you may have something down in Clayton that you'll need to go to after this, because the sentence that I'm going to impose wraps everything up here. You could get out, but at least you'll be released to your hold. So one hold is Clayton County, and we've confirmed that. You got to go down there to deal with a trespass charge. You may also have a hold out of Dunwoody. I don't know what that's for. Okay, you're looking like maybe you know what the Dunwoody thing is about. Okay, so you may have to go there for that. But let's take care of this case, Mr. Moses. I do find that there's a factual basis for your plea. In May of last year, you may have been hungry or probably not cold because it was May, but something, you broke into the Rambler, which is a coffee shop, and took some things. And it sounds like that same day you broke into this young lady's car and took some things. Obviously, you can't do those, but it sounds like you also were in some desperate times in terms of housing and food and whatnot. Doesn't justify it, but it helps everyone understand why you might do that. I also find that your plea is voluntary. That means no one's forcing you to go forward with this, but you've had a chance to talk with Ms. Rios, you're ready to get out, and you want to go forward with the plea. Is that true?
Yes, sir.
Okay. And then your plea is knowing, meaning you've understood what we talked about. And when you didn't, you ask questions. But after those questions were answered, you feel like you understand what your rights are and the consequences of this plea. Is that a fair statement?
Yes, sir.
Okay, then I'm going to accept your plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
All right, and Mr. Moses, can we electronically sign your name on the indictment indicating that you pled guilty?
Yeah.
Great, we'll do that. I'm going to sentence you on count one of the indictment to 5 years to serve 10 months with a balance on probation. Your sentences to counts 2 and 3 are the very same, 5 years to serve 10 months with a balance on probation. They're all going to run together. You have served 307 days. That's a little more than 10 months. So you can be released. It may not be today because it's already the afternoon, but well, of course, you won't be released to the street. You'll be released to the hold. But that means the sheriff's team will call Clayton and Dunwoody, and someone's going to need to come get you, or they'll get rid of those holds. So you're probably off to Clayton next. But we're not holding you anymore. And then you're going to be on probation. You'll be on probation for 4 years and 2 months. That's what remains after the 10 months in custody. Special condition of probation is that you stay off of Georgia Tech property. So if you see a sign that says Georgia Tech, or it's a building you know is Georgia Tech, just don't be around Georgia Tech property. And if you're not sure, you could ask, like, is this a Georgia Tech building? If it is, you need to be in a different building, okay? I will set a behavioral incentive date of March 3rd, 2029, March 11th, 2029. That's 3 years from now. If you've done everything right on probation, they can close it out a little bit early. I hope probation goes well for you. I know you're working through a lot of challenges. I encourage you to plug in with PAD. I cannot make you do that. That's up to you, but they can help you with housing and medical care and things like that. And they've accepted you into their support network. So hopefully when you're done with Clayton and Dunwoody, you connect with PAD. Do you know where they are?
Somebody say they by Garnett.
Yep, they have a place near Garnett, and it may be there's a piece of paper that Ms. Rios can give you. I know they moved recently and opened offices, maybe on like White Street or something.
Is it Wells Street?
Wells Street.
Okay, it has the address.
Yep.
Oh,
So that's for you. And I'm going to waive your supervision fees, so you're not going to have to pay probation supervision fees. I don't know, Ms. Simpson, if I can request a mental health officer. We don't have a diagnosis or anything. Maybe probation will make their own determination.
Suggest the mental health eval.
Yeah, why don't we do that? I'm going to add a requirement that, Mr. Moses, you have a mental health evaluation. So probation will help plug you in with Grady or Mercy Care or somewhere where you can talk with the doctor. And if that doctor recommends you take some medicine that'll help you just think straight, then that treatment that's recommended will become part of your probation. And I think I covered everything. We're putting restitution on hold for now. Anything else, Ms. Smith?
Nothing further.
Ms. Rios?
No, Your Honor, but I think he has a question. He's gonna.
What's that question?
I was about to say they got me on meds now.
Good. All right, and are you taking them?
Yes, sir.
And for what do you take them? What?
Schizoaffective.
Okay, well, that's the kind of medication we want you to get when you get out as well. But it's hard if you don't have a doctor and a car and your favorite hospital and a credit card. But PAD can help with that. And certainly probation will connect you with medical providers who can and help with that prescription. The more you can take that medicine, the better, because then you're not going to hear or see things that maybe aren't really happening and cause you to do some of the things that got you in jail. It'd be great for you to be done with jail for a while. I bet you want that as well.
Yes, sir.
Good. Well, I wish you luck, Mr. Moses. You'll be off to Clayton or Dunwoody soon. You do need to report to probation when you are finally released. When you see the blue sky and are not in jail, you're going to need to report to probation, which is just a few blocks away. Have you been there before on Memorial Drive?
On Memorial Drive?
Yeah.
County?
Pardon me? Nope, not in DeKalb County. We may need to give you one more. You're gonna talk with him? Okay. Ms. Simpson is with probation. She's not gonna be your probation officer, but today she's your probation helper. And she's gonna tell you where you need to report, but better yet, she's gonna give you a piece of paper that has that address. Memorial Drive is actually right near here. Their office is about 3 blocks from the courthouse. And not too far from Pad. Pad could also help you find the probation office. But you got to meet with them so they get you in the system, and you'll be able to tell them where you're staying. Okay? Anything else? You good? All right. Thank you, Ms. Rios. Thanks, Ms. Smith.
Yes.
Have you had a chance to see Mr. Johnson yet, or you're about to do that? Okay. We'll be out here.
Are we gonna be able to call the trial calendar early? Is that what we're doing today?
No, what we're doing today at 4 was to go over the March calendar. You could say, I'm ready on this. This is going to be a plea.
Oh, yeah, that's what I meant. That's what the going over the march.
Yeah, you want to do it early?
Well, then, because then I could do that and then go home versus like rushing home and then getting on the computer.
I want things to be easier for you, Ms. Rios. So let's do that. If you can get the other lawyers on, that's great.
Wait.
Ms. Smith.
Get other people?
Well, Ms. Smith is right here, so that would be easy. Ms. Wood, but I don't have the, I'll go grab my calendar. If there's a murder, then we need to get Mr. Abadi on. I don't know if there's a Willingham or a Williams or a Nix. I don't get the sense we'll get Miss Nix. But we just need to get those, and they may love earlier as well. They may be thinking, who does 4 o'clock calendars? But you should just look at the calendar and see who else is in the mix. And I'm all for knocking it out earlier.
I'm making announcements for ABA.
You're covering Willingham, okay. So I don't know who else is on the calendar.
Text Adam.
Okay,
Who else is?
One got an out now, this one here. We still have to plead.
Judge, it's okay if she's excused.
yes, ma'am, whatever Ms. Simpson said, I appreciate you being here. Hopefully you learned something, but it was nice having you around.
Thank you.
I don't know, he's not free. Never mind.
Oh, Desmond. Desmond. Tell Chief what's happening. Yes, ma'am.
That's Queen Bee.
Ms. Rios wants her meeting now. She wants an Oompa Loompa and her meeting now. She's gonna see if she can get Mr. Abadi to join. I mean, we have Mr. Johnson still to do.
Okay, that's what I thought.
Yeah, and then after that, we could slide right in because Ms. Smith is,
I was looking at this, 148, do we want 230?
what's that? Oh, yeah. No, I mean, it's hard to know. I go by that clock, so it's about 10 of 3.
So what time do you want the truth?
I can't tell what Mr. Johnson's gonna be like. It's supposed to be a plea? Okay, okay.
Non-negotiated?
That's what they said. So 3:30?
Okay.
We're just trying to prevent Ms. Rios to have to hurry home and then get on the Zoom.
Okay, Rios, we got you. I'm gonna stop talking.
They spoke the car, man, he's that car.
He's at cops, so what are they talking about?
They weren't doing their job, I told you. Call again tomorrow. I already sent him a letter, so he should get it then if he's there.
Yeah, I say that. You tell us.
How do I see?
What do you want to check?
The release date of Marcus
Just
Smith.
wondering how long they're keeping. They said May 8th.
Oh, man.
Yeah, that's
It
the.
should be.
Odyssey tells you when someone's getting out?
Yeah, I didn't know that.
Where?
On our end, we know.
Of course, the helpful end, I'm sure we don't get access to that. Who's calculating the release date?
I guess
Yeah,
the
it's
jail.
jail.
Interesting. I don't have to figure out where that is. I'm assuming we can get at it.
It's under,
Release?
he's a report or something.
So like someone who would be in now,
And
but they're under sentence?
they're on the sentence to the jail, they under the jail sentence, like, they don't get sent down the road and they just stay local.
Right. Like if it's a 3-month revocation, they're not gonna leave the jail. Next time we get,
No, I see it in the file. It's on there.
okay.
Well, my security, man, can you tell me my release date?
Today, brother, shh, pop the cell open.
I supposed to get released yesterday.
Oh, I don't.
I'm still here.
I don't miss that. And parole, I don't miss that at all.
I just work here.
I just work here.
Miss that at all. Yeah.
It's like the jail folks be blaming everything on the court.
Oh, we used to get
And
that.
now I'm here, we blame everything on the jail.
We used to get that when I worked at parole. I would get yelled at by grandmothers and baby mamas and mamas and all that. Y'all said that they was supposed to be eligible. Trying to figure out why y'all still got, first of all, we don't have anybody. Let's start there.
Eligible don't mean you get out.
And see, do you understand how they found out that they can explain that?
He's only eligible for pay.
The number of times I had to explain parole is a privilege, not a right to some people. All I remember is somebody, she called me and asked me, and when she and then I started in, and she would have been in the predicament. It dealt with the kind of before she got it. So I like feel kind of on that. Because if he was all that you just described, then he wouldn't have been predicament. So I'm thinking what you need to do. You're doubtless. You failed as a parent. Why are you giving? Wait a minute. Wait a minute.
Wow, ouch.
He wants the toy.
The toilet. So wait, it just about their conversation.
Boom, you failed as a parent. Not even a lead in of like, well, if he'll eat and he'll get the apple slices.
He eats the apples, he drinks the juice, he won't sweat.
I know they haven't been in so long. A good toys?
No, it's not good toys. And then he stuffed the toys in his pocket to take to school the next morning.
My oldest son used to do that. He does Discover Pockets. That's like
Yes.
just Discover Pockets, and everything has to have a pocket now.
Yeah.
He's like, I don't have to change them out of his pajamas if they don't have pockets. I'm like, where are you putting in pockets? Where you live? Where do you waiting?
Lady County.
Oh, you too far. Yeah. Hard.
John Brew.
It's like, how far is that from DeKalb? It's like 30 minutes.
Yeah, everything's 30 minutes away in Atlanta.
Depending on which way you turn it.
My son's shy.
He's shy.
Mhm.
Look is good with shy kids. Like he gets everyone to.
He would not. But once the ice is broken,
Luca goes up to everyone and gives them a hug. He makes some of his friends when we're going to pick up from daycare get out the car if they're already in the car to give them a hug. And he won't leave until he gives them a hug.
Oh, wow.
it's true that they say that once you have a kid, you have no more space. Like
Yeah. Yeah, man, he's always in the bathroom.
I could just be on the couch, so he gotta come climb on you, climb on my head. This.
He has to be like right here.
Okay, so we're gonna try a non-negotiated plea with cases. Please everyone refer to Lonzie as Miss Johnson, and please do not make any reference to mental status today. So we are gonna be very delicate.
So, fine with the Ms. Johnson, but does Ms. Johnson take any medication?
I think so.
Okay, because we need to ask it. Is it better if Ms. Smith asks the medication question or if I do?
We're gonna draw, there's some other physical ailment that is happening that is not mental related that's probably going to be brought out.
Okay,
So yes, but I guess, I don't know.
I'll ask.
Okay.
Okay, so when it's time for that, in fact, I'll just ask us some of the leading stuff and then you skip that, okay? Let's give it a go. You're a brave woman. And if you think about it, you had, what's his face, the revocation and this, I mean, you've had sort of both.
Conley.
Yeah. Conley and this, okay.
What?
You wanna sit down? We can have him sit down. Yeah, we can have him sit down.
Being seated?
Yeah.
Okay. Rios is becoming a prosecutor. Hey, Ms. Johnson. It's good to see you. I'm gonna have you sit if that's okay. Middle seat.
Right here.
Middle, it's not middle anymore. Yeah, that one. All right, let's get on the record. This is State versus Johnson. We've got two cases, 21 SC 179084 and 25 SC 007956. Ms. Johnson is in court with her lawyer, Ms. Wood. We have Ms. Smith for the state as the prosecutor. And it's my understanding, Ms. Johnson, that you are ready to enter what we call a non-negotiated plea. So Ms. Wood is going to be advocating for one sentence.
Okay.
And Ms. Smith, on behalf of the state, is going to be advocating for a different sentence.
Okay.
And I'll decide where we end up. It's judge's job. When people disagree, judge has to figure out what the answer is going to be. In order for us to do that, Ms. Smith is going to put you under oath in just a moment.
Okay.
I have a couple questions for you, then she's going to ask you questions about your rights, about the case, that kind of stuff. You need to answer all the questions truthfully and completely.
Okay.
You also need to let me or Ms. Wood know if at any point you've got your own questions because you're confused by something, or Ms. Wood told you it's going to go this way and it starts to go that way, then I'll try to explain why things are going that way. I'm not worried about you not understanding stuff, but if something comes up, you need to tell me that. Will you do that?
Yes, I will.
Sounds like a plan. All right, let's start with the oath.
Ms. Johnson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand.
Ms. Johnson, I'm going to start and then I'm going to hand it over to Ms. Smith for the rest of the questions. I need to know if you are currently taking any medication for anything.
Well, they put me on some kind of amoxicillin, and I keep coming up in the jail with what I tell you what? Bladder infection.
Okay, so you're taking a antibiotic to help with the bladder infection.
Correct.
Any other medication?
But I keep, so for some reason, every time I get locked up, they keep putting me in the mental status in there. Why do they keep doing that?
Don't know. That's a
They're
medical.
giving me some kind of stable pill to keep, I guess, keep me.
Okay. Do you take those? Do you take those pills?
I take it in there, but I'm on the outside because.
But whatever the doctor at the county jail has prescribed, you've been taking.
Well, I really didn't ask to take that. I suffer with depression.
Okay.
Depression ain't got nothing to do with mental.
Well, I'm not going to argue with you about that, but I know that plenty of folks would say that being depressed is a mental health condition because it saps your energy and you're this and that. But as long as you are
saying the way they're treating me like I'm a real mental case, and I'm not.
okay,
I'm not a bad.
no one in here is saying you are.
Okay.
I just want to make sure. Really, the reason why I'm asking is if any of the medication you take makes you woozy or drowsy or confused. I need to make sure that's not happening to you right now. I need you to be.
I'm just tired of my whole body jerking and jerking around. That done got on my nerves. I don't know what's causing it. Maybe I did have a mental breakdown, but
Okay.
I'm sick and tired. It's on basically on my left side.
Okay, but for right now, you feel like you're understanding what everyone is saying.
Understanding everything.
You understand why you're out here. It's to enter a plea in your two cases.
Correct.
Great. If at any point you start to get confused, you're going to tell me.
Correct.
Then I'm going to hand it back to Ms. Smith.
Okay.
Ms. Johnson, how old are you and how far have you gone in school?
I graduated from Avondale. I went 12. I'm 50, Lord, I think 1970. I think I'm 57 or 58 now.
What year were you born?
1970.
Okay, you're not 57 yet. When's your birthday?
July 11th.
Okay, you'll be 56 this year. So you're a young 55.
Oh, really?
Yeah.
Yeah, I'm confused.
All right.
I've been.
Look at that. I just shaved a couple years off your life.
Okay, thank you.
Congratulations. And you graduated high school.
Yeah.
Okay.
Avondale.
Ms. Johnson, are you able to read, write, and understand the English language?
Well, actually, I was in remedial classes coming up, but I can very understand it.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes,
And if you
ma'am.
plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known
Yes,
to you
ma'am.
regarding this indictment?
Yes, ma'am.
Ms. Johnson, I need to make sure, even though you know the answer coming up, you can't buzz in early. So let Ms. Smith finish the question.
Okay.
Because the court reporter, who is virtual, she's watching and listening.
Okay.
She can only write what one person says at a time.
Oh, okay.
And so you've been answering kind of mid-question because you know where the question's going. Wait till Ms. Smith's done, then give your answer. That way the court reporter will get down everything you have to say.
Okay.
Thank you.
You're welcome.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
In certain areas, I'm gonna be honest.
Is there any reason why you think we should not go forward with Ms. Wood as your lawyer?
Yes, we can go forward with Ms.
Okay,
Williams.
great. It's not, few relationships are perfect. You guys have had your bumps, but you're comfortable having Ms. Wood advocate for you. Okay, but you're not waiting for people to finish talking.
Oh.
Let's not talk over each other. I won't interrupt you. Don't interrupt Ms. Smith or me. You're comfortable having Ms. Wood handle this situation for you right now?
Yes.
Great.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Ms. Johnson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to the charges?
We do not.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
I just remember she's gonna ask for probation and I'm gonna ask for something else. That's all that
Okay.
means.
Yes, I understand.
And were you made aware of the state's offer prior to you coming out today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I understand. I have a question.
What's that question?
The question is, okay, if I decide to not really plead, but probation, would it hinder me for getting on back on Atlanta Housing Authority? They don't do accept felonies.
So
See,
being,
see this mess I'm going through you now, Your Honor, that's why I got kicked off Atlanta Housing Authority, dealing with these street mobs. I'm not in a mob.
do you already have any felony convictions?
I don't know if any felonies on my record or not. Last time I checked, it was for drinking in public, and what they thought I was drinking in public, but that's what they ended up charging me.
Okay,
And
well,
that was basically it. And the last time I was in front of you, that was basically it.
well, we're going to reach a point where I ask someone from pretrial during our conversation to share with me your criminal history.
Okay.
If you already have a felony, then this isn't going to change whatever your status would be with the Atlanta Housing Authority. If you've never, let me finish. If you've never been in trouble before, this could have an impact on that. So it's a fair question. But let's wait to hear from Ms. Stallworth when we get to that.
Okay.
Okay, Ms. Smith?
Yes. Ms. Johnson, do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on the federal case?
Yes.
Are you currently on probation?
No.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes. And see, that's the part I was kind of bothered about. Give me a firearm, and I live alone. I'm by myself. And then
Well, it's definitely a consequence.
Your Honor.
I interrupted you. I'm sorry. You
Go
finished.
ahead.
No, I need to do what I
And that's
said.
the reason why I had a hammer.
Okay.
Go ahead.
Nope. I apologize. I spoke over you. But it sounds like you do understand that an impact, a result of a felony conviction is that means no firearms for you.
Correct.
Yes to hammer, yes to axe, yes to machete, no guns. Okay?
Okay.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yeah, I understand, but I understand everything I done.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you,
Correct.
the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney,
The right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges. The right to testify on your own behalf or remain silent. The right to present other evidence of your own and call your own witnesses. And the right to appeal if convicted of these charges after a trial.
I understand.
Counsel, are you satisfied your client understands that these are the rights they'll be waiving by entering this guilty plea?
Yes.
Ms. Johnson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
They do that every day in the park, honey. They do that over there in Rice Street. Bullies, yeah, I mean, but go ahead. Yeah, I try to ignore it.
Well, I'm going to follow up on that one. I recognize that being in custody is frightening and dangerous, and you might encounter people who don't treat you well. The question.
Go ahead, I interrupt you again. Sorry.
We're learning. We're both learning. The question, Ms. Smith, that the point Ms. Smith was focusing on is whether you feel like you're entering the pleas today in your two cases of your own free will. Or is there someone back there at the jail in your private life saying, Ms. Johnson, if you don't plead, I'm gonna hurt your mom, I'm gonna hurt your kid, I'm gonna break your arm, or
I figured that it told us two apart, me and my two sisters, what's going on with me, and her husband has a lot to do with it. But I try not to put other people's mess into my mess. But like I said, I very understand what you're saying, and I'm just ready to get this over with. I am ready to go home.
Okay. And your readiness to go home is maybe what's motivating you to
I know
enter.
it's by you. I know.
Okay, but you're entering this plea because you've decided that's what you want to do.
It's what I want to do, Your Honor. I just need to get this over with. Just like when you always have asked me, do I have an opinion behind yours? And I feel that I'm ready to get this over with. I've been walking these streets and being myself for over so many years, and all of a sudden I'm coming into trouble as I get older. I'm getting sick and tired of it.
Okay.
And then it's really not only the inmates over there, it's part of the correction officers too. I'm just sick of it.
Then it sounds like you're ready to move forward because you want to put that
I want
behind
to
you.
move forward with the rest of my life.
Yep. Okay.
Right. As to indictment number 25 SC 007956, how do you plead to count 1, aggravated assault?
Yes. Guilty at my best interest.
Okay. And regarding indictment number 21 SC 179084, how do you plead to count 1, aggravated assault?
Pleading guilty at my best interest.
Are you aware that even if you do not admit guilt, that this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes, I guess.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Do
you understand what the state is pledging?
Not really.
So I do understand what they tried.
Right.
So then yes.
Yes. Yes.
Yes, okay. Do you understand that you do not have a right to appeal your guilty plea, but if you feel like that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
The same.
So if you withdraw the plea, then you have that right. So do you understand that part?
I can withdraw what part?
So it's in your we still have to withdraw.
Okay.
So say yes.
Yes.
Okay. Do you understand that that has to be completed within 30 days from today?
Correct.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Say it one more time.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Ms. Johnson. Your Honor, if this case were to proceed to trial, the state would show an indictment ending in 9084 that on.
Let me ask this.
Okay.
Ms. Wood, having spoken with Ms. Johnson, do you feel that there is a factual basis from your review of discovery to support the state's allegation in the 084 indictment, which charges aggravated assault in June of 2021?
Yes, Judge, that is the case where we had done the virtual PTI.
Mhm.
So I know there was a factual basis for it to be charged. I don't know if we went to trial, if we would move all the way forward, but there was a factual basis at that time.
Sure. And similarly, do you believe, having reviewed discovery and discussed this with Ms. Johnson, that there's a factual basis for the state's allegation of aggravated assault in the June 2025 case? Okay. Now, Ms. Johnson, that's not Ms. Wood saying, gosh, we'd be found guilty at trial. It's Ms. Wood saying, you know, if all the witnesses came in and said exactly what's in the police reports, a jury could decide that something happened along the lines of what was charged. It's not Ms. Wood saying you're guilty. In fact, you've entered a guilty plea in your best interest, and that's how we'll record that. So I'm comfortable that both sides agree that there's a factual basis for your pleas, and we're going to turn to Ms. Smith to see if she's got anything else.
Yes, Your Honor, regarding the recommendation from the state.
Yes.
An indictment ending in 7956, the state is recommending a sentence of 10 years to serve 1 with the balance probated. Also, for indictment ending in 9084, the state is recommending for count 1, 10 years to serve 1, balance probated. And for both of those indictments to run concurrent. Regarding the special conditions of probation, the state will be requesting that the defendant stay away from the incident's location in both cases, for the defendant to have no contact with both victims, and for the defendant to complete an anger management course. And I believe that the defendant was accepted into pass, so we would just encourage or, encourage the defendant to participate with that if possible.
All right, we'll see what Ms. Wood has to add about that. And let's turn to Ms. Stallworth. Good afternoon, Ms. Stallworth. Last set of cases for you for today. I appreciate you being available. Do you have criminal history information on Ms. Johnson?
Yes, Your Honor. She has 11 cycles total. There are no felony convictions listed on the GCIC. And then there were 2 FTAs. Nothing further to report.
Thank you. So there's your answer, Ms. Johnson. Your criminal history has 11 arrest cycles, no felony convictions. So we're moving into some new territory for you. I would like to hear from Ms. Wood now.
Judge. So Ms. Johnson has actually done over the recommended amount the state's asking for when you combine both jailings. She's done 683 days total. For the first go round, so let me back up. It's interesting because when I'm looking at the Fulton County jailings, it is literally just disorderly conduct from 2005, and then it skips a couple of years, and then Ms. Johnson is not arrested until 2016, and it's simple battery, so it's all relatively minor misdemeanors. And then of course we have the 2021, the first aggravated assault, and now the 2025 second aggravated assault. It has always been Ms. Johnson's position that she was protecting herself. So, who knows how it would shake out at trial. The first go around in 2021, this was actually a virtual PTI case, and I've said it a couple of times, but I'll say it again for purposes of this record. It was a virtual PTI. She was accepted to PAD at that time, and it was absolutely not her fault that she wasn't able to go to the program. There was the DeKalb County hold that threw a wrench in all of our plans, and we could never get DeKalb to get on board with lifting the warrant.
Was it resolved? What happened with the DeKalb situation?
I don't know. That's why I had stayed in school. So once I got out a year from here, because I was wondering why I was in here for so long. So when I got over there, they said the warrant, something hadn't been lifted. So I had to go back over there with a piece of paper. And they end up lifting or did some kind of paperwork. I don't know what they did. I don't know what they done.
Got it.
But it's messing me up.
Okay, well, it looks like it's been resolved because when your 2021 arrest
And
When you were released from that, you went to DeKalb.
I'm so sorry, y'all.
You okay?
Okay.
So yes, so Judge, I think the DeKalb County case did resolve that. It was also a misdemeanor hold at that time.
Mhm.
And then, so she actually did 406 days here, waiting on us to figure out a resolution. And then, of course, the DeKalb hold pops up. Instead of, if I remember correctly, I think this court actually did an order for Ms. Johnson to return, and DeKalb did not honor the order. So at that point, Ms. Johnson then ended up with the sister that she's referenced in South Georgia. And then I'm not really sure what happened, but she's back here now. And so this time around, she's done 277 days. Judge, we've worked with Grady and the team at the jail to make sure that Ms. Johnson is good to go. Ms. Smith and I have been working, trying to find the best resolution here. Like I said, she is able to return and work with Pat. I'll just get a new release date if the court goes for that. My request of the court is just to do suspended sentences on both cases, just conditioned upon, I guess you could structure it that way. If it's a suspended sentence, that she continue to work with Pat and no violations of the law.
Okay.
And to take any prescribed medications.
Got it. Hi, Ms. Williams.
Hello.
All right, Ms. Johnson, I feel like I have a much better understanding of the situation with what Ms. Wood has shared and what you've been sharing. Is there anything more you want to add before we get to my part of the process?
Yes, like I said, I just like for this to be old so I can go on with my life. I'm a single person. And, that's basically it.
Okay. Well, I respect your desire to be able to move forward with.
If I have to do much time, could you please move me to, if I have to be moved?
Okay. I will honor that request as well. I think that's going to be moot. So Ms. Johnson, we've already talked about a factual basis. I also agree there's a factual basis for your pleas. And I find that your pleas are both knowing, meaning you've understood what we talked about. And when you didn't, you speak up, you let us know. And then Ms. Wood or I answered your question. So it's a knowing plea and it's a voluntary plea, meaning you've decided that it's in your best interest to go forward with these pleas. Do you agree with that?
I agree.
Okay, then I'm accepting your pleas. Ms. Wood, can someone in my office sign your name to the two indictments?
Yes.
Ms. Smith? And Ms. Johnson, we now electronically sign a lot of the documents just so we hand less paper around. Can we electronically sign your name to the two indictments indicating your, we call them best interest pleas in the two cases?
Yes.
We'll do that. I'm going to sentence you as follows, Ms. Johnson. In the older of the two cases, 21 SC 179084, I'm sentencing you in that case to 5 years to serve 1 year with a balance on probation. You'll get credit for the time you served, which is more than 1 year on that case. So that's not going to hold you in anymore. Special conditions of probation are: number one, you stay away from that incident location and you stay away from Alice Wade. That's the named victim in that case. I assume that's not a relative or someone that you're still close with. Okay, so that's an easy one. You will also need to continue to take any medication that doctors you choose to see prescribed for you.
What you think is like I said, I think I done had a mental breakdown.
Okay. Well, if you choose to see a doctor and that doctor says, hey, Ms. Johnson, you should take these blue pills, then you need to take the blue pills. No one's forcing medication on you. It's if you go to a doctor and your doctor says you'll be healthier because of the infection or because of this or that, take this medication. I'm just letting you know, taking that medication becomes a part of you taking care of yourself. Okay? And I will require you to complete one anger management course that probation will help you line up. I'm waiving your probation supervision fees. So you're going to figure out how you get food on your table and clothes on your body, but you're not going to need to worry about paying probation supervision fees.
Okay.
You have a second case, and that is 25 SC 007-956. And in that case, I'm sentencing you to 5 years to serve 9 months with a balance on probation. You have not served more than a year on this case. You served just over 9 months. Combined, you served way more than a year when you add both these up, but you cannot receive credit on the newer case for all that time you served back in 2021, because that was before this case even happened. But you served 9 months. So you'll be on probation a little bit longer in this case, but it also is not going to hold you in jail any longer. Special conditions are the very same. Stay away from the incident location of the newer case. This is the Hammer case, and no contact with William Gordner. Do you know who that is?
No.
Good. Then it's going to be easy to stay away from him because he's a stranger.
Okay.
And you will have your supervision fees waived. You'll take any prescribed medication, and you'll complete this one anger management course. Now, I'm going to recommend that you participate in PAD, but PAD does not, they won't work with you if I make it part of probation. So it's not part of probation. It's a great opportunity for you, and I encourage you to follow up on it. But that's Ms. Johnson exercising her own free will if she's going to work through PAD. Okay. And really what I'd like to do if PAD's accepted you is get a transport order from Ms. Wood. And so you will be released to PAD. They will take you to PAD's office. You'll meet with PAD. You're going to be released with a 30-day supply of whatever medication you're taking right now. And you'll be off and running in a good way.
Okay.
All right. Any questions about any of that?
Yes. How would I go through the anger management class? You think I need it?
I think it's not going to hurt you, and probation will help you line that up. You don't have to get online and say, well, is there an anger management course? Your probation officer is going to give you a list or a roster or a phone number to call or a website to go to or a place to lock up to, and then you'll get through it.
Walk up to you to find it.
Okay, well, you'll talk with your probation officer about that. And you will need to report to probation within 48 hours of being released. Ms. Simpson's going to give you that information about where to go and when to go. But the when, I'm telling you, it's within 2 days of being released.
Okay.
And you don't want to miss that first appointment, because what they do is just send me a warrant saying Ms. Johnson didn't show up. And you don't need to go back to Rice Street. Okay?
Okay.
Ms. Wood, anything else in Ms. Johnson's cases?
Only, Judge, that, just that we hold the dispositions until I get the release order to the court.
We'll do that, or what I can put in the dispositions is Ms. Johnson will be released pursuant to separate order, and generally the jail holds on to folks. But I know you don't take long to get those orders, so they may just all happen at the same time. Okay? Ms. Smith, anything else in Ms. Johnson's cases? All right, thank you, everyone.
Yeah, I have a question. Oh, God, I don't know. Back about.
Right now this down for you so that you have it.
Ms. Stallworth, thank you for your time. You are good to go.
Thank you, Your Honor.
And Ms. Rivers, thank you for your time. You're good to go.
You're welcome, Judge. See you on Thursday.
I think that would, how far is it from?
Ms. Rivers, see me, yes, but we've got drug court tomorrow, so you'll plug in towards the end of drug court.
Yeah, I'll be on tomorrow.